Welcome to the 2014 Ohio High School Mock Trial State Championship. Good morning. I'm Stephanie Bucher with the Ohio Supreme Court's Office of Public Information. We are live from the Senate hearing room at the Ohio State House in Columbus. What you will see today is a polished performance by these students who will be arguing a fictional court case live in a real courtroom setting before a panel of judges. What adds to the drama is that all season, each team has been preparing for both sides of the case, and they only found out a moment ago whether they will be arguing for the plaintiff or the defense. Since last fall, teams of high school students have been preparing and competing against one another, and the top two teams have advanced here today for the championship round. Those teams are Orange High School, the Lions from Pepper Pike, and Sylvania Southview, the Cougars from Sylvania. This is Orange's second year in a row in the finals, so we wish them the best of luck, and Sylvania has won 5 titles, the most of any team. So the winning team today will be representing Ohio in the national championship that will be coming up in Madison, Wisconsin. Our sponsoring organization for today's Ohio Mock Trial competition is the Ohio Center for Law-Related Education, or OCLRE. They've been educating students about their constitutional rights and responsibilities through this program since 1983. The Supreme Court of Ohio, along with the Ohio State Bar Association, the Ohio Attorney General's Office, the ACLU of Ohio Foundation, are OCLRE sponsors. And after growing steadily over the past 31 years, OCLRE's Ohio Mock Trial program is now the largest non-athletic competition in the state, with more than 3,000 students participating and more than 1,000 legal professionals who've been volunteering as their legal advisors, case committee members, and judges. Joining us now from OCLRE is the High School Mock Trial Program Coordinator, Todd Birch. And Todd, thanks so much for being here today. When we talk about the largest non-athletic competition in the state of Ohio, how many students, how many schools have been participating through the competition this year?
Thank you, Stephanie. I'm happy to be here. This year we had approximately 180 schools with more than 330 teams for well over 3,000 students participating in this year's competition.
And when did they actually start preparing for this?
Each year, the case is released at the Ohio Center for Law-Related Education's Law and Citizenship Conference in late September. Students have had the opportunity to work on the case since that time.
Okay, and what have they been doing to prepare for today?
The type of preparation might vary by the particular school. Students will often set up scrimmages with other local mock trial teams, work in real courtrooms preparing their parts, and of course work with their legal advisors and their academic advisors to build the skills that are important to be successful in the mock trial program.
So you mentioned the adult support that they're getting from their advisors, and you also mentioned some actual attorneys have been helping them as well?
Absolutely. Each team in the competition is supported by one legal advisor and one academic advisor. In addition to that, the program is fortunate to have the support of more than 1,000 legal professionals who volunteer their time as judges, committee members, competition coordinators, and team advisors.
How much time does it take for the students and for their adult support staff, if you will, to get ready for this?
Obviously, again, the amount of time can vary from team to team, but as you may imagine, to get here today, it is a significant time commitment. The typical team will meet and practice several times a week, either in class for those schools that feature mock trial as a classroom component, or after class as an extracurricular activity.
What is the main goal of providing this type of programming, this mock trial program for Ohio students?
As with all of our programs at OCLRE, the main goal of this program is education. We want to educate the students regarding the legal system, the Constitution, and their rights. We also want to help them build skills that will be successful not just in a legal career, but in other careers, including public speaking, self-confidence, and critical thinking.
So you talk about learning some of those skills that they need to kind of be prepared for making their argument, and some of those you already mentioned. What are some of the other things that you're hoping that the students learn through this whole process?
As I mentioned, I hope that they'll have a better understanding of the Constitution, a better understanding of their rights. For instance, this particular case is based in a school setting and involves the rights of students, and a better understanding of how the legal system functions and how they're able to protect and argue for their own rights within that system.
All right. And then what should we be looking for today for this particular case?
You'll see the students argue regarding the First and Fourth Amendments in their school. It's important to look for, in terms of the presentation today, you'll see students that are very polished, very focused on the presentation, I think making very effective arguments on both sides to the judges. Hopefully you'll see very balanced, very poised arguments from each side in today's case.
What happens for the winning team after today?
The winning team will represent Ohio in the National High School Mock Trial Competition in May, and this year that competition will take place in Madison, Wisconsin.
Okay, well, great. Well, we're looking forward to seeing the kids in action as they get ready to get their mock trial presentation all ready to go before the judges. So thanks very much, Todd. Really appreciate that.
Thank you.
Okay, and in fact, we're going to learn a little bit more about the specifics of the facts and legal issues that are going to be presented in this year's case that the students are going to be arguing in just a few minutes. The case is titled Phillips School District versus Jesse Springfield et al. The facts of the case are that Phillips High School, a fictional case that's been created just for today, was agreed to license naming rights of its sports field to a large corporation. The students at the school organized protests both in the school and on the field. The school district responds by installing security cameras and searching lockers of the students that have been involved. The school also files a lawsuit seeking an order authorizing the school to remove the students from the field. Now, the students are claiming that the school district's actions violated their First and Fourth Amendment rights. The First Amendment concerns freedom of speech and assembly, among others. Sylvania Southview will be arguing for Jesse Springfield and his classmates that the school violated those rights to speak and express their views. And they're also going to be arguing under the Fourth Amendment right to be free of unreasonable searches and seizures, that the school violated their constitutional rights by installing security cameras and searching their lockers. Orange High School is going to be arguing for the school district position. And to learn more about this and other aspects of the case, let's talk with Lisa Eshelman. She is the director of the Ohio Center for Law-Related Education. Lisa, welcome. And I want to give a little bit about your background. You are actually a lawyer, so you have been in the legal field for a while. How different is this case from real life?
Well, what we are very, very fortunate to have is our case committee is comprised of lawyers and judges who use their years of combined experience to create fact patterns and legal issues that very much are real true to life. So I think what we'll see today is what we would expect to see in a courtroom, in any courtroom across Ohio.
And how important is it for the case committee when they come up with these types of cases to make it so that the kids can relate to?
Well, of course, when we're talking about kids who are in high school, when we find fact patterns in which they can relate, where they see that their constitutional rights as well as their responsibilities are at issue, it makes it much more engaging for them. And as we know, the cornerstone of everything that OCLRE does is that it's based on educating kids about the Constitution. And so the case committee always puts the constitutional issues at the forefront of the case.
Why is that important to have the kids understand their constitutional rights at such a young age, really?
Well, what we do know and what's been a cornerstone of our democracy is that we can't be an effective democracy if we don't have active, engaged, and knowledgeable citizens. And so OCLRE was created to help high school students and now both elementary and middle school students understand that those rights, responsibilities, knowledge will make them more engaged when they become citizens.
What are some of the things that we should be looking for in the audience if we've never been to a trial, never been to a mock trial?
Right. Well, the judges will be scoring the students on both their understanding of courtroom procedure as well as their understanding of the issues and the facts. So all three of those together are the kinds of things we're going to look at. What the judges will be looking for in the students' performances today is their poise, their ability to ask questions for the witnesses, how they respond to those questions. And then what is most difficult for young people learning how to try cases is how do they respond to the things that we don't know about, all of those surprises that come up in any trial.
Mm-hmm. And how close is the mock trial to what we would see in a real trial setting?
I think it's going to be very, very realistic to what we would see in a actual trial if we were down in Franklin County or any other common pleas court in Ohio. These are somewhat smaller in terms of the number of facts that are issued. That might be the biggest distinction between what we would see.
All right. So what are you looking forward to as you sit and watch the arguments today from our two teams?
Well, I always are thrilled when I actually get to see the case come to life. I've seen bits and pieces of the case since September as the students have worked through districts and regionals, but I've not yet had the opportunity to see it all the way through. So that's what I'm going to be doing today.
Okay, great. Thanks so much, Lisa. And we'll have a chance to talk with you again right after the students present their oral arguments.
Oh, that's fabulous.
So
Thank you very much.
Thanks, Lisa. I appreciate it. And so we look forward to hearing her analysis on how the students performed. And now let's get Jared Wrights, who is the Director of Programs at OCLRE, to talk a little bit more in general terms about your organization. What are this is not just the only program that you have. What are some of the other programs that you offer to students in the state?
Well, it would be interesting to note today, in particular, looking at a mock trial, we've initiated a middle school mock trial program, and it's based on pieces of literature that is read at the middle school level. We like that because we believe it's collaborative, and the kids begin to learn these skills, but they're also reading good literature. And we also have We the People, the Citizen, and the Constitution, which is also performance-based, as this is, but it's simulated congressional hearings. And we do that at the State House in the actual hearing rooms, and the students prepare some very in-depth questions about the Constitution and the Bill of Rights, and then they are questioned by members of the legislature and other members of the legal community. We have that for middle school as well. We have a program that deals with intolerance and injustice called Youth for Justice. We have a program that deals with public policy called Project Citizen, and then some teacher programs. We partner with teachers to bring citizenship to life.
All right. And so the mission for the Ohio Center for Law-Related Education comes all back to what those programs are doing for the students.
Yes, absolutely. And like I said, everything we have has an authentic assessment. So students actually learn by doing. You know, it's not paper and pencil. And it's authentic because we bring in those people like attorneys today or members of the legislature or other members of the community to interact with kids. So it's not just role play. They're going through something authentic like you will see today.
And they're doing research. They're looking at different avenues to find out how they can best present their case. It's not a script. I mean, you didn't present them with everything they needed to know to present today.
None of our programs are that way. Students have to begin to develop these. These are student-driven in many cases. With the Constitution and the Bill of Rights, they have to begin to read it, find information elsewhere, talk to people, because that's the best learning. Learn by doing. And all of our programs are related to the standards in terms of English language arts and social studies. So they're really collaborative. Teachers can work together on these. And they're not all extracurricular. With We the People, it has to be a rostered class, so it has to be an academic class.
Sid, we were talking about how the students today are going to be presenting to a panel of judges. Can you explain a little bit about who we're going to be talking, who they're going to be talking to, and how in their scoring?
Well, they're going to be looking at some of the sharpest legal minds here in the state, and they're coming from around the state. And the students will, I know, they prepared their speeches, but they have to think on the cuff, and that's what some of these people will be looking for.
Great. Jared, thank you so much for your time. We appreciate that, and we're looking forward to seeing how those students are arguing the case. And so now let's take a look at the competing teams that we're going to be hearing their arguments from. Orange High School is arguing for the plaintiff, Phillips School District. Orange is located in Pepper Pike, which is near Cleveland here in the state of Ohio. This is the team's second straight year in the finals. Orange High School has been part of mock trial for 14 years, and this is their second year with 10 teams in the competition, which is the most teams among all the schools who participate. The seniors on this year's team competed as freshmen in the state finals. Sylvania's Southview High School will be arguing for defendants Jesse Springfield and his classmates. Sylvania's Southview is located in Sylvania, which is near Toledo. The school has been part of mock trial for 19 years with 18 straight appearances at states, 14 Final Fours, and 5 state championships dating all the way back to 1996. They were finalists in 2010. Sylvania Southview also won the 2013 Empire International Championship. So we wish both teams the best of luck, and we look forward to seeing all of their hard work pay off in today's championship round. The mock trial should be starting in just a few minutes, and it will last about an hour and a half before the judges break to score the teams. And at that time, we'll be back with more information and lots more interviews, including we'll be talking with some of the students. While we have a chance, let's talk about this beautiful room and its history. Again, we are in the Ohio Senate hearing room at the Ohio State House. And at one time, this was a law library, so that's an appropriate setting for a mock trial. Additionally, the Ohio Supreme Court used to hold its sessions in the room that is directly above us in what is now the North Hearing Room. Today, the Ohio Supreme Court has its own building, the Thomas J. Moyer Ohio Judicial Center, which is just a few blocks away from here on Front Street. So, without further ado, let's go down to the main floor of the courtroom where the teams are about to argue the fictional case Phillips School District versus Jesse Springfield et al. In the 2014 Ohio High School Mock Trial State Final.
welcome both teams. This is the case Phillips School District versus Jesse Springfield. Before we begin, I want to introduce the members of the scoring panel. I will be the presiding judge today in the trial. My name is Jerry McBride. I'm a judge of the Claremont County Court of Common Pleas, and I'm a member of the high school mock trial competition committee. And if the scoring judges would introduce themselves.
Good morning. I'm Deborah Allspaw. I'm family court judge in Marion County.
Good morning. I'm John Hollingsworth. I'm a practicing attorney from Dayton. I'm the president of the Ohio State Bar Association.
Hello, I'm Stephen Tilson. I'm a practicing lawyer from Galion, Ohio, and I'm the president of the Ohio State Bar Foundation.
Are both sides ready to proceed then? Yes, sir. Okay. Plaintiff may proceed first then.
May I proceed?
You may.
Your Honors, my name is Ariana Cerquera, and I'm an attorney for the plaintiff, the Phillips School District. I'd like to take a moment to let my teammates introduce themselves.
Good morning, Your Honors. My name is Megan Shanklin, also an attorney for the plaintiff.
Good morning, Your Honors. My name is Chloe Antrobus, and I will be playing Jamie Gomez for the plaintiff.
Good morning, Your Honors. My name is Christoph Tomsick, and I will be playing Casey Mancuso for the plaintiff.
May it please the Court. Your Honors, the American public education system has an incredibly important mission within our country: to provide students with a safe and healthy learning environment. Within Phillips High School, however, this mission is being threatened by the disruptive behavior of the student group Occupy, which is why we're here today to request that the court grant a temporary restraining order against the defendants, Jesse Springfield and the student group Occupy, ordering them to vacate their makeshift tent city outside of the football field. Now, while Phillips believes that students should be able to express themselves and share their ideas, during the school day and on school grounds is neither the time nor the place. Today we will prove, by both clear and convincing evidence, that Phillips meets each requirement necessary for the granting of a temporary restraining order. Phillips has a substantial likelihood of success on the merits, seeing as Occupy is neither a school nor curriculum-related group. Therefore, they are not entitled to or allowed to use school grounds, including the area where their tent city now sits. In addition, Occupy is severely disruptive to the school environment. Phillips will suffer irreparable harm if the motion is not granted, because it will be unable to maintain order and discipline within the school, a significant governmental and community interest. Now, this not only harms the school, but more importantly, the student body at large. No injury will be caused to others in the granting of this motion, seeing as the students of Occupy have many other outlets of communication readily available to them. And finally, the public interest weighs in favor of Phillips for several reasons, in which we will demonstrate today. Now, at the end of today's case, we will also respectfully ask the court to deny the defendant's motion for a TRO against Phillips, in which they are seeking to restrain Phillips from conducting legitimate searches of their lockers and backpacks, as well as from confiscating other unauthorized Occupy-related materials. The defendants will be unable to prove that they have a substantial likelihood of success, seeing as their First and their Fourth Amendment rights were never violated. We will call two witnesses to the stand today, Your Honors. Dr. Jamie Gomez, principal of Phillips High School, will explain to the court that the student handbook states that unless the club registers and is approved by the principal as curriculum-related, they are not allowed to use school facilities. Therefore, she will explain that since Occupy never got her approval, Occupy cannot be considered curriculum-related, and they are not allowed to camp out on school grounds. In addition, Dr. Gomez will explain that the district's actions to restrict Occupy on school grounds were consistent with existing school rules and were only reasonable time, place, and manner restrictions that are content neutral. Casey Mancuso of the Phillips Police Department will prove that the searches conducted of the students' lockers and backpacks were indeed reasonable and justified, and that there was no violation of the students' Fourth Amendment rights, seeing as the searches conducted were justified at their inception and reasonable in scope. He will also explain about the many other outlets of communication that were not only available to the students of Occupy, but already actively used by them. And finally, Officer Mancuso will testify to the severely disruptive effect Occupy's actions had on the school. Now, Your Honors, in our nation, schools must maintain order and discipline within their hallways so that they may be able to carry out their most important job, educating the bright young minds of America. and Phillips High School is no different. Which is why, at the end of today's case, we will respectfully ask the court to deny the defendant's motion for a TRO against Phillips and grant the motion of Phillips so that these students may vacate their tent city and finally restore order back to the school. Your Honors, there is a time and there is a place for everything. But the student's current occupation outside of the football field is neither the time nor the place. Thank you, Your Honors.
Defense counsel, you may make your opening statement.
Yes, John. Before we begin, may we make our appearances?
Yes.
Good morning, Your Honors. My name is Eric Su. I will be delivering the opening statement for the defense, as well as the cross-examination of Dr. Jamie Gomez and the direct examination of Alex Chen.
Good morning, Your Honors. My name is Chen. Today I'll be conducting the direct examination of the defendant, Jesse Springfield, the cross-examination of Officer Casey Mancuso, and at the conclusion of the hearing today, the closing arguments on behalf of the defense.
Good morning, Your Honors. My name is Zach Bochekai, and I will be portraying the role of Jesse Springfield.
Good morning, Your Honors. My name is Catherine Dong, and I will be portraying the role of Alex Chen.
Thank you. Counsel for the plaintiff, you may call your first witness.
Oh, Your Honor, I believe I have to give opening statements.
Excuse me.
Not yet.
Hopefully the only mistake today. So go right ahead.
Your Honor, permission to step in front of the podium?
Yes.
May it please the court, our schools are to be a marketplace of ideas, an opportunity to educate young minds of personal liberties and to promote a robust exchange of views. Instead, this case brings to the court Phillips High School's efforts to constrain creative thought, to censor free speech, and to invade a person's privacy. Now, the plaintiff has claimed today that Phillips High School's actions were taken to provide a safe, healthy learning environment. But the evidence today will show that Phillips High School's actions were only taken because of one reason: to stop the content of Occupy's message. Now, in today's TRO hearing, the defendants, like the plaintiff, will examine the 4 factors of a TRO. First, substantial likelihood of success on a trial of the merits. Second, irreparable harm. Third, the absence of prejudice to third parties. And fourth, public interest. And in applying those issues to the facts of the case today, the defendants will establish 3 points. First, that the plaintiffs will fail to prove through clear and convincing evidence that Tent City presented a substantial and material interference with the school environment. Second, the defendants will establish that same burden of proof that the school's removal of Occupy leaflets was an unlawful, content-based restriction under the First Amendment. And third, the school's search of the defendants' personal belongings and seizure of their cell phones violated their Fourth Amendment rights. In reaching that outcome, we will call 2 witnesses to the stand: the defendant, Jesse Springfield, and his U.S. history teacher, Alex Chen. They will both take you through Occupy's efforts at free speech, the school's retaliatory response, and the school's further inconsistent application of policies used to quiet the movement. As you'll learn today, upon the announcement of the deal, a group of students objected to the corporatization of their school, which involved changing the name Freedom Field, which honored veterans, to Fructose Field. Forming a group known as Occupy, the defendants gathered support for their cause through social media, hosting flyers around the school, and hosting meetings. And as public and student support gathered for Occupy's cause, NFC pressured Principal Gomez to shut down the protest or lose the deal. Then, and only then, did the school take action to stop Occupy. It was there that the attack on Occupy's content could be seen, because as Jesse Springfield will testify today, in an effort to shut down Occupy's protests, the school ripped down Occupy flyers off the walls, harassed students handing out those flyers, and censored pro-Occupy articles from entering the school newspaper. Now, while the school justifies its action today based upon claims of interference, the evidence today will show that there was no violence as a result of Tent City, no destruction of property attributable to these defendants, no material and substantial interference to school operations. With student support still growing for the Occupy students, the school then threatened the defendants, telling them that if they didn't stop protesting the NFC deal, that there would be dire consequences. And as you will learn at that time, Occupy stopped their protests in the school and instead moved them outside. Following recent protests in U.S. history, Occupy set up Tent City to voice their dissent. And as the testimony of both Jesse Springfield and Alex Chen will show today, Tent City was a peaceful, symbolic protest free of drugs, violence, and any criminal behavior. Still, the very next day, without reasonable suspicion, the school cut open the defendants' lockers, searched their personal belongings, and seized their cell phones. It is for these reasons, because of the content-based restriction of Occupy's message, that we as the defense respectfully ask you to preserve the marketplace of ideas at Phillips High School by denying the plaintiff's TRO motion today and instead granting the defendants. Thank you.
Thank you. At this time, if you'd have your witnesses step forward, I'll ask the bailiff to swear in the witnesses, please.
Will all witnesses and parties swear to give testimony in the please step to the front. Please raise your right hand. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, and your testimony will comply with the rules of the Ohio mock trial competition? Yes, sir. You may be seated.
Counsel for the plaintiff, now you may call your first witness.
Yes, Your Honors. At this time, we call Dr. Jamie Gomez to the stand. May I proceed?
You may.
Hello, Dr. Gomez. Nice to see you again.
You too.
Could you please state your name and occupation for the court?
Of course. My name is Jamie Gomez, and I am the principal of Phillips High School.
And how long have you been with Phillips School District?
It's been a while, about 30 years now.
Could you please tell the court about your educational background that qualifies you for this job?
Of course. I received my undergraduate in economics from Harvard University. I carried on there at Harvard to also obtain my master's and PhD in education.
All right, Dr. Gomez, let's talk about why you're actually in court today, the deal with the NFC.
Mm-hmm.
Were you involved with that agreement?
I was, yes.
And what exactly was your involvement?
Well, when the National Fructose Corporation came to me with an interest in investing in our community, supporting our school district, I was more than happy to serve as a sort of liaison between Lee Martin of NFC and the other school board members.
So what was this deal about?
NFC was offering Phillips $500,000 to replace our old high school stadium with a new artificial turf, to underwrite all costs of the deal, and all they wanted in return was naming rights to the stadium and management of food sales, vending machine sales, things like that.
So what did you think about this proposition?
I thought it would be extremely beneficial towards Phillips, towards the entire community, not only serving as a cost-saving measure, but also improving the safety of anyone who wanted to use the field.
Okay, so in what ways did it save costs?
NFC would be providing a constant flow of revenue from food sales, from vending machine sales. But also, most importantly, Phillips wouldn't have feasibly been able to go ahead with this deal without the financial assistance of a company like NFC.
And Dr. Gomez, you also mentioned that it improved safety. Mm-hmm. How did it do that?
Well, with the goal of improving safety and experience of our students being one of our #1 goals in Phillips, the turf field would simply be much safer.
All right, Dr. Gomez, let's talk about what happened after this deal actually went through. How did the students at Phillips react to it?
Most students were actually really excited about the deal, especially student...
Your Honor, lack of personal knowledge.
May I respond?
Sure.
Dr. Gomez is the principal of Phillips High School, thus she interacts with students on an almost daily basis. These are simply her rationally based perceptions pursuant to Rule 701 as a lay witness.
Response, Your Honor?
Yes.
Ms. Gomez cannot testify today to the mindset of each of these students that they were excited about the deal, and therefore she has a lack of personal knowledge to their own mindset towards the deal that can't be based, on her observations.
This is a permissible opinion. You'll be able to cross-examine. Certainly on that point, objection is overruled.
Yes, Your Honor.
So, Dr. Gomez, you're talking about how the students at Phillips reacted to the deal?
Yes, most students were really excited about it, actually, especially student government members and, of course, the athletes that would be using the field. However, there were a minority of students who didn't like the deal. They began to criticize it immediately. One of these groups called themselves Occupy.
Can you talk a little bit more about this group, Occupy?
Of course. I first learned, that they were an unregistered, non-curriculum-related group that had been protesting the NFC deal. They were not only meeting on school grounds, but proved to cause a number of other problems all over campus.
Were there any other groups that protested this deal besides Occupy?
There were a few.
So what was the difference between these other groups and Occupy?
Well, the other groups were registered and Occupy never registered.
Okay, Dr. Gomez. Did Occupy ever come to you personally to express their concerns?
I actually had a meeting with several representatives from Occupy. I wanted to listen to their concerns about the deal and why they had such a problem with it. Unfortunately, their actions didn't change at all, actually, after we met.
Let's talk about those actions. What exactly was Occupy doing in school?
Right. Well, Occupy began meeting at first. These meetings were impromptu and planned in the cafeteria, in the hallways even, which was extremely disruptive.
How so?
What would happen would be members of Occupy would start vigorously debating with anyone who wanted the deal to go through. And this would cause other students who weren't even involved in what I can only describe now as near altercations, really, to be late to class. And the fact is, there's a time and a place for everything, right? But in the middle of our school day, in the middle of the hallway, is not the time or the place to be doing these kinds of things.
Dr. Gomez, was anything else going on in school at this time?
Yes. Now that you mention it, there were copious amounts of flyers hung all around the school in support of Occupy against the NFC deal.
Your Honors, at this time, I move to introduce what has previously been stipulated as Exhibit A to the court. Please note that I am showing opposing counsel a clean and unmarked copy of this exhibit. May I approach the witness?
You may do so.
Your Honor, I would request, as discussed in pretrial, that given the amendments that the errata sheet makes to Exhibit A, that errata sheet be taken up along with Exhibit A for the purposes of evidence.
Say that again.
I'm sorry. Because of the amendments that the errata sheet makes to the content of Exhibit A, I would request that the errata sheet be taken up along with Exhibit A to preserve the record.
And to the extent that the errata sheet changes the facts in the statements, yes, that will be recognized.
Yes, Your Honors. I can bring a copy. All right. May I approach the witness with a copy of Exhibit A and the errata sheet?
You may do so.
Thank you.
Dr. Gomez, can you please tell the court what this is?
This is the Phillips High School Student Handbook, as it says, select provisions.
And how familiar are you with this document?
After working here for so long, pretty familiar. I see it on almost a daily basis.
And how available is this document to the students of Phillips?
Well, as it says right here, a copy is provided to each school. We actually give a copy to each student, and they can always pick one up in the Student Services office. They're free.
And Dr. Gomez, in regards to Occupy specifically, how familiar are you with that group's actions?
I would say extremely familiar. I mean, I observe them directly.
So, based upon this familiarity with Occupy's actions and the student handbook that you're holding, were any of the rules in that handbook broken by the club?
Yes, they were. Just at a quick glance, most of the rules in non-school sponsored publications were disregarded. For example, the flyers that were hung around the school were hung during the school day, which clearly violates Part B of Rule 3. They were hung without an author's name on them. There was no signature, which completely disregards Rule 4. And the first time I saw these flyers was not on my desk, but already on the walls of the high school, which completely violates Part A of Rule 3. I have to approve all flyers hung in the school to make sure they're appropriate and that they follow all of the rules. Whoever hung them up obviously skipped a few steps.
Dr. Gomez, why do you enforce these rules?
Primarily, I think, to increase the educational experience of the students to prepare them for after they leave high school, but also with over 40 student groups and activities all around the school, it's important that all of them follow the rules. Don't get me wrong. I, of all people, am completely for expressing your opinion and, stepping up for what you believe in, but I just can't tolerate disruptive activity or contempt for established rules and policies in Phillips.
So, beyond all of this, what else, if anything, was Occupy doing in school at this time?
Right about now, they were becoming increasingly disruptive, raising their profile much more than before.
And as principal, how did you respond to that?
I felt like I had no other choice but to increase surveillance around the school, as many other schools had already done in the area, to decrease any further misconduct. I also asked Detective Mancuso, who was an undercover agent in another investigation at the school at the time, to keep an eye on them.
So Mancuso did an investigation. What did he find?
First, that there'd be a tent city at the high school that night in protest of the NFC.
Let's talk about that tent city. What did you do when you heard about it?
I followed protocol, as I always do. I informed the parents and the students of all of the rules that they were breaking. I also went ahead and locked the stadium gates to prevent any further trespassing.
So, Dr. Gomez, you knew about Tent City in advance. Why did it still happen?
Well, I needed Mancuso to first maintain his cover as a student so he could be on the ground at Tent City and obtain any evidence that might be there.
All right, so what did you do following his investigation at Tent City?
Well, based on the reports of hacking and unauthorized Occupy literature...
Objection, Your Honor. I believe the specific report to hacking does call for double hearsay in the evidence of the witness.
May I respond?
Yes.
Your Honors, this is not hearsay. This is simply a statement being used to explain Dr. Gomez's subsequent actions. This is not being used for the truth of the matter as per Rule 801.
Response, Your Honor.
Can I hear your question again?
It was, what did you do following Mancuso's investigation at Tent City?
Yes. Your Honor, I believe opposing counsel is indeed offering the statement for the truth of the matter because, as I believe Principal Gomez will later testify, she used this evidence given by Officer Mancuso to justify her continued custody of the phones of the students to this day.
Objection is overruled.
Yes, Your Honor.
So, Dr. Gomez, I believe you're talking about what you did following his investigation?
Yes, it was. Well, based on all of the information I had, as I said, I felt it necessary to ask Detective Mancuso and Ms. Jacobs, the school custodian, to search the lockers, where they ended up finding all of the unauthorized Occupy literature. I also met with the students individually. I asked Jesse for his cell phone because of the serious hacking accusations against him. Unfortunately, he didn't want to put the whole thing to rest and just give me his password, so obviously I couldn't search his cell phone further.
And Dr. Gomez, these locker and these backpack searches, why did you feel that they were necessary?
For the purposes of restoring order back to Phillips, to stopping the disruptive nature of Occupy, so that the school could move forward with the NFC deal, so that the benefits could be provided to the students to better their education, to better the faculty's experience, and the entire community of Phillips. The searches were the first step in doing this. And as principal, I simply needed to enforce the rules.
Thank you. No further questions at this time.
Do you have any cross-examination?
Yes, Your Honor.
You may do so.
My place is here. May I proceed?
Yes.
Dr. Gomez, you're looking to retire once this deal is completed, correct?
In a while, yeah.
And one of the places you're looking to retire to is potentially NFC, correct?
Oh, yes. Well, NFC is one of many options.
And you've pursued this option so far as to having conversations with individuals at NFC about job prospects, correct?
Well, they came to me because of my background in economics, but again, I've had many conversations with many companies, but I really don't plan on working very soon after I retire. I want to take a few years off.
Just to be clear, Principal Gomez, returning to my original question, you did indeed have conversations with individuals at NFC about job prospects there.
They came to me.
Correct. And then following this, Lee Martin is also the individual who represents NFC for the purposes of this deal, correct?
I believe so, yes.
And isn't it in fact true that Lee Martin has been your friend since you were classmates at Harvard?
We're old friends.
To be clear, upon the announcement of this deal with the NFC, there were several groups protesting protesting the NFC deal, correct?
Yes, as I said before.
And just to be clear, Occupy was not the only one engaging in protest activities.
It was the only unregistered one, non-curriculum related one.
So returning to my original question then, Occupy was not the only group protesting NFC.
No, but they were the only ones breaking the rules.
Okay. We'll talk about the rule violations later, Ms. Gomez, but firstly, and I wrote this down just to be clear, in direct examination you stated that the school is not the time and place for Occupy's protests. You stated that, correct?
Yes, and I believe that.
Just to be clear, you as a principal encourage students to express their ideas through student groups, don't you?
Of course, without breaking the rules.
And to be clear, you encourage this expression, this exchange of ideas, even if the views are misinformed.
Of course, I support any child stepping up for what they believe in. I believe that it betters their educational experience. I do.
Okay. So, for example, one of the ways Occupy expressed their ideas was through their online petition, correct?
The online petition that was open to the entire internet. Is that the one you're referring to?
That's the online petition, yes.
Yes.
And when you learned of this online petition, you informed Lee, didn't you?
I did, because it concerned his deal.
And when you informed him, he was, in your own words, not too pleased about this, was he?
Of course not. The people who he was trying to help were protesting against the deal.
So, to be clear, he was not pleased.
No, I don't know why he would be.
Then Occupy began posting leaflets, correct?
Yes, all over the school.
And then you learned of a pro-Occupy article that was being submitted to the school newspaper, correct?
Yes, that article had libel towards the NFC. It was completely inappropriate.
Principal Gomez, is your testimony here today that the article that was submitted had libel contained within it?
No, I just said that I didn't let it in the newspaper.
And you didn't let it in. You prohibited it, without ever reading the contents of the article, correct?
No, I saw the article.
So again, Principal Gomez, is your testimony here today that you read the full text of this article prior to your prohibition?
Why would I not let it go into a newspaper without reading it first?
So just to clarify, that is your testimony here today?
No, I just stated that I didn't put it in. These are the reasons why I didn't put it in the newspaper.
Principal Gomez, returning to my original question, did you or did you not read the article prior to your prohibition?
I did, but I didn't really feel the need to state that in my affidavit.
So just to be clear, then, it is not in your prior sworn testimony that you read the article?
No, only that I didn't put it in the newspaper.
Okay. Now, the very next day after this article was submitted, you had another meeting with Lee Martin, correct?
Yes.
And during this meeting, he was incensed, wasn't he?
He was a little concerned, yeah.
Principal Gomez, I believe in your prior sworn testimony, you referred to him as incensed, didn't you?
You can use that word if you want. Yeah, it's fine.
It's the word you used, wasn't it?
Yes, I believe so.
And he was incensed about the community's scrutiny of this deal that was caused by Occupy, correct?
Of course, again, the community who was trying to help was reacting badly to the deal. It didn't really make sense.
Well, regardless of whether or not it made sense, the purpose of this meeting with Lee Martin was to discuss ways to counteract this negative publicity.
Yeah, we wanted to show the public how positive the deal could be for them.
After this meeting with Lee Martin, isn't it in fact true that you decided to immediately and strictly enforce the policy against Occupy?
Yes, as legitimately as I could, based on these school rules.
And the way you enforced it following this meeting with Lee Martin was tearing down Occupy flyers from the walls, correct?
I actually asked the custodians to take them down. I'm not sure if tearing off is the right
But you did
verb.
instruct the custodian to remove Occupy leaflets after the meeting with Lee Martin.
Of course, they were breaking the rules.
But just to be clear, Principal Gomez, prior to the meeting with Lee Martin, you never ordered anyone to remove Occupy flyers.
And then there hadn't really been a problem before. The flyers became more and more apparent in the school after this meeting.
So returning to my original question then, Principal Gomez, you did not remove Occupy flyers prior to the meeting.
No, as I stated before.
Okay. Now, when intensity occurred, you had another conversation with Lee Martin, correct?
Yes, I believe he called me.
Well, during this conversation, isn't it in fact true that Lee was the one who suggested you file a lawsuit to remove Tent City?
Yeah, I thought it was a good idea. I mean, we couldn't actually forcibly remove 40 students without following proper legal protocol.
So then is that a yes to my question? Lee was the one suggesting that idea? And to be absolutely clear, your TRO claim today here is indeed to remove Tent City.
Yes.
Now, Tent City has been occurring for roughly 2 to 3 weeks, correct? And in that time, isn't it in fact true that you have no evidence of violence at Tent City?
No.
Isn't it in fact true you have no evidence of any destruction of property at Tent City?
No.
And to be clear, the first night that Tent City went up, you didn't even attend the event, did you?
I met with Mancuso after.
But returning to my original question, Principal Gomez, you did not personally attend the event.
No, I'm not sure the students would have wanted me there.
Objection, Your Honor. I move to strike the latter part in the witness's statement as non-responsive. I didn't ask what the students wanted, whether or not simply she was there.
Yes. Objection is sustained. You can re-ask the question.
Yes, Your Honor. So, Principal Gomez, to clarify, then you were not present at Tent City?
Not for the former half, but I showed up later to meet with Mancuso. That's where I met with him.
And when you met with Mancuso, he told you he did not observe any overt illegal acts.
Objection calls for hearsay.
Response, Your Honor?
Yes.
This is not being offered for the truth of the matter pursuant to Rule 801C, but rather just to demonstrate the environment at Tent City that night.
May I respond?
Yes.
Using this statement to demonstrate the environment at Tent City is in fact using the statement for the truth of the matter because it is demonstrating that Mancuso's statement were true regarding the environment at Tent City.
Let me hear your question again.
When you met with Officer Mancuso, he told you they didn't observe any violations of school rules.
The objection is sustained.
Yes, Your Honor. And to be clear, the very next day, you had the lockers of the defendant searched, correct?
Yes, because information I had, I felt like it was necessary to see what was in the lockers.
And to be clear, the lockers were searched by Officer Mancuso, correct?
I informed him too, yes.
As well as the custodian.
Yes, you need a staff member when you're searching lockers.
And Officer Mancuso, who is not a staff member, also searched the backpacks of the students, didn't he?
I informed him too, but I ended up confiscating the items.
So, returning to my original question then, Principal Gomez, Officer Mancuso did indeed perform the search of the backpacks.
No, I confiscated the items.
Principal Gomez, yes or no, did Officer Mancuso perform the search of the backpacks, not the confiscation of the items?
Objection asked and answered.
Your Honor, may I respond?
Yes.
The witness was not responding to my question with a clear yes or no answer, or a clear answer in general, so I was clarifying the question to receive that answer.
Yeah, I agree. I'll overrule the objection.
Yes, Your Honor. So, Principal Gomez, yes or no, you instructed Officer Mancuso to search the backpacks of the students?
I did instruct him to.
Yes. And to be clear, you instructed him to search it because you wanted to scare the students into ceasing their protests. Isn't that right?
The students need to understand how severe the situation was and that there were consequences to breaking all of the school rules.
Principal Gomez, returning to my original question, you did indeed want Officer Mancuso to search the backpacks to scare the students into ceasing their protests.
Well, over the 30 years of being principal, I've seen that sometimes the best way to make the kids understand how serious the situation is by scaring them a little. I mean, it was a scary situation.
Objection, Your Honor. I move to strike the latter part in the witness's statement as non-responsive. I didn't ask what her rationale was, simply whether or not she did indeed want Officer Mancuso to scare the students with the search.
May I respond?
Yes.
Asking what she wanted is asking for her rationale. Thus, Dr. Gomez was indeed answering the question.
I'm going to overrule your objection.
Yes, Your Honor. So, Principal Gomez, that was your statement in your prior sworn testimony, was it not?
Yes, as I stated before.
And when the backpacks were searched, did Officer Mancuso have a warrant?
I don't know. I was not part of the actual investigation. That's why I asked a detective to come and do it.
So, Principal Gomez, just to be absolutely clear, did Officer Mancuso have a warrant, yes or no?
As I said before, I was not in charge of the investigation. I'm not sure.
Well, Principal Gomez, you were there during the search of the backpacks, weren't you? And you, Officer Mancuso, was under your jurisdiction for the duration of the undercover investigation, correct?
Yeah, that's why I confiscated the items, because I don't need a search
Given
warrant.
all of this, is your testimony here today that you do not know whether or not Officer Mancuso had a search warrant when he conducted the search of the backpacks?
I'm not sure because I confiscated the items and I don't need a search warrant.
And when the backpacks were searched, the cell phones of the students were removed, correct?
Yes.
And you asked permission to search these cell phones, didn't you?
Of course, I would never search a cell phone without getting permission first.
But you were denied this permission, correct?
Yes.
And when you denied this permission, isn't it fact true that you then threatened the students with dire consequences, if this subordination continued?
I'm not sure if threatening is the right word. I let them know again how severe the situation was and that there are consequences. How people in the past, students in the past that have violated the rules have had problems in the future because of the violations.
Yes or no, was that not the statement you made in your prior sworn testimony?
I believe if you word it like that, I guess so, but I was simply letting them know that there were consequences.
So that was in your prior sworn testimony?
Yes.
No further questions, Your Honor.
Thank you. Any redirect?
Briefly, Your Honor. May I proceed?
You may.
Dr. Gomez, on cross-examination, your motivation regarding this deal was drawn into question. Why did you feel that this deal was a good fit for Phillips High School?
As I said previous times before, this deal would provide benefits financially for the school. It would give the school a new morale to have a new turf field where the old playing conditions were just simply, they were a lawsuit waiting to happen. So I think that this deal would help Phillips in so many ways and benefit so many different people.
And Dr. Gomez, regarding the protest to this deal, what were the other groups like, besides Occupy, that were protesting the deal?
Well, there were other groups, as I stated before, but they were registered and they were following all the rules. There was no need to interfere with anything they were doing.
And Occupy specifically, you were asked about their flyers. Why did you take down Occupy's flyers?
Occupy's flyers were breaking the rules. That is why I instructed the custodian to take down the flyers.
Thank you. No further questions.
Any recross?
Very brief recross, Your Honor. May I proceed?
You may.
Now, on redirect examination, opposing counsel questioned you about your policy concerning the leaflets, correct?
Yes.
Occupy's leaflets were violating the rules prior to your meeting with Lee Martin, correct?
Yes, but there were less of them around the school.
Is that yes to my question, then, Principal Gomez? They were violating the rules prior to Lee Martin.
Yes, but as soon as I had enough information, I ordered a search, as I always do, for things that are violating the rules.
And you only removed Occupy leaflets following the meeting.
Well, I would have removed them before if I had enough information or if I knew about them.
Returning to my original question, then, Principal Gomez, you did only indeed remove of leaflets after the meeting. No further questions, Your Honor.
Thank you. Witness may step down.
Thank you, Your Honors.
You may call your next witness.
Your Honor, at this time, the plaintiff would like to call Officer Casey Mancuso to the stand.
Good morning, Your Honors.
Morning.
May I proceed?
You may.
Good morning, Officer Mancuso. It's nice to see you again.
Good morning.
Could you please state your name and occupation for the court?
My name is Casey Mancuso, and I'm currently an accident investigator for the Phillips Police Department.
And where did you get your training?
Well, shortly after graduating from high school, I applied to over 50 training academies in the Midwestern United States, and I was accepted to the City of Phillips 2012 Police Officer Training Academy. Additionally, I am taking some law enforcement classes at the local community college.
So, what did you learn while at the academy?
I was trained on both the First and Fourth Amendments to the U.S. Constitution, and additionally, I learned 6 core values that I have incorporated into my daily thinking and practice. These are honesty, professionalism, adaptability, attention to detail, self-discipline, and overall hard work.
All right, let's move on. How is it that you ended up at Phillips High School?
Shortly before graduating from the academy, I was assigned to conduct undercover drug investigations at the high school.
And could you tell us a bit more about these investigations?
Absolutely. See, every large metropolitan area has drug-related problems in their high schools. However, our previous efforts at intervention and using students as informants had severely underestimated the impact of the problem. I met with Principal Gomez and my commander, and Principal Gomez outlined the drug problem to me and provided me with my full fake identity, Casey Sanderson.
All right, well then, how did you become involved with the case at hand?
About 5 to 6 weeks before the end of the school year, my assignment was modified to incorporate a new investigation, one that had nothing to do with drugs.
And what did you learn from this meeting?
I learned that NFC had recently moved some of its construction equipment and machinery onto the school grounds and found that it had been vandalized with spray paint by a tagger using the initials NSA. And apparently this damage and vandalism had been done the same day as an impromptu Occupy meeting in the school cafeteria.
All right, now, what happened to your assignment in the school after this meeting took place?
My assignment turned into a more thorough investigation. I would infiltrate Occupy and report on them and their activities to the principal and write a daily report to my commander.
All right, now, what did you learn about the vandalism or other subsequent acts?
At first, the principal and commander both expressed their concern that it was just a student who thought that they were smarter than the authorities by using multiple play-on words and a misleading moniker, in this case NSA, meaning no such agency. However, on a more serious note, this vandalism seemed to be a felony criminal investigation, and Occupy was seriously considering several options to physically prevent the NFC and the school board from going forward with their plans.
All right, now, how did you investigate into Occupy?
Well, because it could be considered a felony, I was given more leeway in the methods and tactics that I could use to investigate Occupy. I went to their meetings, and as part of my undercover work, attempted to gain the trust of my student targets.
All right, now, what did you learn from these investigations?
At first, Occupy wasn't doing or planning anything illegal. They would go forward with legal protests, online petitions, planned demonstrations that are all common in America today. But to continue my investigation, I went to subsequent meetings and recorded the attendance there in order to conduct social media research to help me identify who the 5 leaders of Occupy in this lawsuit today are. These are Jesse Springfield, Terry Silva, Alex Leslie, Storm Jackson, and Trilby Van Ecker. And I'd seen all of these students run Occupy meetings.
All right, now, how did Occupy plan all of these meetings and protests?
Well, Occupy would use various social media platforms, such as cell phones, smartphones, and laptops to organize many of their protests. And they would also use Facebook and Twitter to create and post about events. And the members of Occupy would call other students at the high school in order to get them more involved and get them more encouraged to actually show up to the stadium gate.
All right, now, what went on at subsequent Occupy meetings?
Well, there was more discussion on illegal activities, such as hacking school computers.
Objection, Your Honor. Hearsay?
Your Honor, may I respond?
Yes.
These statements are showing intent, plan, or motive, and this is an exception to the hearsay rule under 803.3.
May I respond, Your Honor?
Yes.
Specifically under 803.3, they can't be used to actually prove the fact of a matter, and that's what Mr. Mancuso is trying to prove today. But furthermore, we believe that the information that Officer Mancuso has testified actually occurred after an Occupy meeting and is not attributed to any of the Occupy students, specifically the 5 defendants here today. Therefore, this is hearsay.
Objection is overruled.
Yes, Your Honor.
Would you like me to re-ask the question?
Yes, please.
So what went on at subsequent Occupy meetings?
Well, there was more discussion on illegal activities, such as hacking school computers, disrupting normal school functions, and actually occupying school property. Now, the Occupy organizers would say things like, we should do whatever it takes. And sometimes you have to break the law in order to get noticed and get the man.
Hearsay once again?
Your Honor, may I respond?
Yes.
This is not hearsay, seeing as it is an admission of a party opponent. We have clearly established that the Occupy 5 were the organizers and those who ran the group. Therefore, they act as representatives to the group Occupy. Therefore, this is an exception to hearsay as set forth by Rule 801(d)(2).
Response, Your Honor.
Yes.
There's been no foundation to be laid that any of the 5 defendants here today were even present at the meeting where those statements were made. There's been no evidence to show that these students were running the specific meeting that Mr. Mancuso is testifying to, and thus it's not an adopted mission, it is hearsay today.
Your Honor.
Yes.
May I respond? We have clearly established that the Occupy 5 were those who ran and organized the meeting. Therefore, Occupy organizers does refer to the Occupy 5.
I think you're going to have to establish some foundation. I'll sustain the objection.
Yes, Your Honor.
Okay. Who seemed to be the main perpetrator at these meetings?
The main perpetrators seemed to be Jesse Springfield and obviously the other Occupy 5, because I'd seen these students run Occupy meetings before.
All right. And how do they make plans to physically prevent the NFC?
Well, Jesse advocated for a tent city, which would involve trespassing on school property and setting up tents in front of the stadium gates to prevent the NFC construction equipment and machinery from entering the field and being able to install the artificial turf.
All right. Now, how did this whole Occupy versus the NFC dispute affect the school?
It greatly affected the school. Everyone was talking about the deal and the protests and what was going to happen. Even I couldn't escape it, especially in Alex Chen's U.S. history class, where I found that we were talking more about Occupy than whatever the topic of the day was, whether it be the civil rights struggle of the 60s and 70s or the Vietnam War.
All right. So how did you participate as a member of Occupy?
Well, Jesse had given me a template of an Occupy leaflet, which I copied and handed out.
And how did you feel about doing this?
I felt uncomfortable, and I didn't want to do it, but it was my job to follow orders, not question them. And I needed to gain the trust of my student targets by acting as a member of Occupy. And it wasn't as bad as buying or doing drugs in the school, which I've had to do in the past as part of my undercover work.
Okay, so while you were at Occupy meetings, what did you see the leaders do?
Well, I'd seen these students actually run the Occupy meetings, moderate Occupy discussions, pass out leaflets on school grounds, and actually post up copies of the posters onto the hallway walls and in the cafeteria as well.
Did you notify Principal Gomez about these leaders?
Yes, I did.
And what did she do?
Well, after I explained that these 5 students, these 5 leaders, were conspiring to engage in illegal activities, the principal issued them a warning letter to cease and desist all their Occupy-related activity. However, that night, a meeting was held at the field in which Construction for Tent City was agreed upon, and a bunch of militant ideas were proposed.
Right, so what happened the day after this tent city was constructed?
The next morning, Principal Gomez instructed Pat Jacobs, the school custodian, to cut the locks off of the 5 lockers of the individual leaders and directed me to search, inventory, and seize all locker contents.
And what happened with these locker contents?
Well, we turned the materials over to Principal Gomez, and upon the students' arrival at the principal's office after they were informed that their belongings were in her office, she and another school administrator informed them that their backpacks would be searched, which they did while I only observed.
Thank you. No further questions at this time, Your Honor.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Now, Officer Mancuso, I just want to get a layout of the details of the case that you were assigned to specifically. As you stated in direct examination, you thought this was a felony criminal investigation of vandalism, correct?
Yes, that did seem to be that.
Right, and based on this investigation specifically, you were asked to look into Occupy, right?
As part of the investigation of the vandalism, I was asked to infiltrate Occupy.
Now, would you say that from the police academy you were taught to be attentive to detail?
Absolutely.
You were taught to be careful in your observations?
Absolutely.
So based on your careful observation of what Occupy did you ever see Jesse Springfield commit a single act of vandalism with your own eyes?
Seeing specifically one of these members, especially Jesse, commit a specific act, no, I did not.
So that would be fair to say that none of the 4 other defendants here today, you never saw them commit a specific act of vandalism with your own eyes either, have you?
I did not see them specifically act upon this militant chatter that they were always discussing, so yes.
Okay, and in addition to that, over the course of your investigation of the group Occupy, you never made a single arrest of any individual, correct?
No, we had not obtained a search warrant to obtain an arrest.
Right. In fact, at the very end of your investigation, isn't it true that you actually apologized to your commanding officer for not getting enough information to make a search warrant?
Well, I did express my sorrow to my commander because we had not obtained enough evidence to obtain a search warrant for the students' persons or phones, but in this case it was not needed because of reasonable suspicion.
Objection, Your Honor. I move to strike the latter portion of the witness's statement as an improper opinion. It's an improper interpretation of the New Jersey versus TLO case where the legal standard is reasonable suspicion. Officer Mancuso is not qualified to make such an interpretation.
Your Honor, may I respond?
Yes.
Officer Mancuso is a police officer, therefore he is allowed to give his opinion on this. It is not improper.
Response, Your Honor.
Sure.
This is a legal interpretation of the New Jersey versus TLO case. It's the reason why we're here today. It's part of the defendant's TRO hearing to stop the search and seizure of the students' belongings. This is an improper legal opinion, regardless of whether or not Officer Mancuso is actually a police officer. He can't testify as to the legality of searching a student's belonging in the school environment.
The objection is sustained. I agree. I think it's a valid objection.
Yes, Your Honor. Move to strike the statement from the record.
The portion of the statement that you're referring to is ordered stricken.
Yes, Your Honor. So, Officer Mancuso, back to that original question, yes or no, didn't you specifically apologize for not obtaining a search warrant to your commanding officer?
As I said before, yes, I had not obtained enough evidence to search the students' persons or phones.
Okay. Now, at this point, I want to focus on your investigation in 3 specific phases. The investigation leading up to Tent City itself, and the events after Tent City. So we'll start with the very first segment. At the very beginning of your investigation, it was your job to infiltrate the group Occupy, correct?
Yes, as I mentioned before, as part of the investigation of the vandalism incident.
So essentially, it was your job to be part of the group and be with them as much as possible, right?
I would say that it was my job to investigate the vandalism.
So it would be fair to say that you had ample opportunity to observe the actions of this group.
Well, as part of my undercover work, yes, I would act as a member of Occupy.
And leading up to, just before Tent City, based on your observations of Occupy, you never saw a single member of the 5 defendants here today get into a fist fight, did you?
I'm sorry, could you repeat that, please?
Based on your observations of the group Occupy, before Tent City, you never saw a single one of the students get into a fist fight at school, did you?
A fist fight, no.
You never saw any incidences of the students participating in vandalism, right?
As I said before, I never had seen them specifically commit these acts, but they were constantly discussing it.
And you never saw any specific violations of the law that can be attributed to Occupy students in the early stages of your investigation, correct?
They were discussing chatter about hacking school computers, which obviously does violate state law, and obviously trespassing on property does violate law as well.
But back to my original question, you never saw specific members in the beginning stages actually act out on any of those, did you?
Well, I would say that the tent city does violate the law.
I'm asking about before tent city.
Tent city is involved in that question, though.
Before, Officer Mancuso, before your tent city itself, did you ever see Occupy members acting out on illegal activities?
Acting on their illegal activities, no, I did not see them specifically do that. But they obviously were planning them, and they obviously did succeed in following through with one of them.
So we'll talk about tent city, and I want to move to the next segment. And in your direct examination, you mentioned something. You said that they were advocating for a, quote, bunch of militant ideas. Did I say that correctly?
Well, to propose a bunch of militant ideas, yes.
Okay. And some of these militant ideas were proposed at a meeting just before tent city, right?
They were, yes.
But specifically to that meeting, isn't it true that in your own prior sworn testimony you stated that no consensus was actually reached at that meeting?
Well, yes, the meeting had run out of time, and as we've stated before, the Occupy group does need a democratic vote in order to reach consensus, and the meeting had run out of time, so they were not able to actually vote.
But the only consensus that they reached was to establish 4 basic rules at tent city, correct?
Yes, sir.
And those rules were no drugs.
It's true.
No alcohol.
That's also true.
No weapons.
It's true.
And no violence.
Yes, if any of these 4 would have happened, the tent city would have been immediately demolished because obviously the police was involved.
Right, and tent city still stands today, right?
It does, yes.
So it'd be fair to say that none of those 4 rules were violated based on the criteria that you just established.
As I said before, if any of these were violated, it would have been immediately demolished.
So that's a yes to my question. None of these rules were broken.
Again, yes.
Okay. Now let's look to the final segment that we're talking about today, and that's the search after tent city.
Okay.
Now, as you testified in direct examination, you searched the lockers, right?
I did, yes. I was directed by Principal Gomez.
Now, you seized the belongings from the lockers?
After inventorying them, yes.
Isn't it true that you had no search warrant when you did so?
As I said before, there was none needed.
Okay. But regardless of which, that's a yes to my question, you did not have a search warrant.
Yes, there was none needed.
And after this, you took the belongings to Principal Gomez's office.
Yes, we did.
And at that point, Principal Gomez searched the backpacks, right?
She did, along with another school administrator.
So if Principal Gomez says that you searched the backpacks, that's not true, is it?
I don't believe that Principal Gomez ever said I searched the backpacks.
So but the fact of the matter is, you only observed the search of the backpacks, right?
As I said in direct, yes.
And when you searched when those backpacks were searched, before they were closed, weren't they?
Could you repeat that, please?
Before Principal Gomez actually searched the backpacks were closed, weren't they?
I believe that they were.
You couldn't see inside the backpacks, right?
I wouldn't say that I can.
So when Principal Gomez opened the backpacks, at that point, she pulled out some leaflets?
The Occupy leaflets, yes.
She pulled out a smartphone?
She did.
Officer Mancuso, isn't it true that when Principal Gomez pulled out that smartphone, you, in your own words, questioned under what authority she had to do that?
I didn't know specifically which authority she had, but I'm sure that there was because, I had never actually seen a copy of the school rules, but in my high school, the principal was always allowed to do that.
Objection, Your Honor. I move to strike the latter portion of the witness's statement as non-responsive. The question simply asks whether or not he made that statement to this degree that he did not know what authority, not his interpretation of it, not his background of his past high school.
Any response?
Your Honor, my witness is simply trying to answer the question with the best visibility.
Objection is sustained.
Yes, Your Honor. So, Officer Mancuso, I'll ask that question one more time. Yes or no, isn't it true that you actually, specifically related to that search, you questioned under what authority Principal Gomez had to seize that smartphone?
Well, as I said in my sworn testimony, I did not know specifically what authority she was able to confiscate the items under. However, I'm sure that in the school rules it may have been permitted.
But, Officer Mancuso, you don't know the school rules.
I have not seen a copy,
So
but I'm sure it is.
Actually can't testify whether or not it's permissible under the school rules.
I would say that it's probable for me to testify
Objection,
that.
Your Honor. I move to strike the latter portion of the witness's statement as speculation. He just testified that he does not know the school rules. He's never read the school rules. Therefore, he can't give testimony as to probably or probably not it's admissible under those rules.
Any response?
Your Honor, my witness is not speculating that it is in the school rules. He's saying he's not sure.
Objection is sustained.
Yes, Your Honor. So, Officer Mancuso, isn't it true that you do not understand what authority Principal Gomez had to seize those smartphones?
As I said before, I did not know specifically what authority she had to search and confiscate the items, although it may have been permitted in the school rules, as I said before.
And you don't know the school rules, just to clarify.
I have not seen a copy of them, but I'm sure it's in there.
No further questions, Your Honor.
Any redirect?
Briefly, Your Honor.
You may.
Now, Mr. Chen brought up on cross your investigation into Occupy. Why did you infiltrate Occupy?
Well, as part of the investigation of the vandalism, Occupy was the prime suspect, and in order to infiltrate Occupy, I needed to act like a member of them. And as part of the investigation of the vandalism, in order to find out what their motives were for everything, I was supposed to infiltrate Occupy.
All right, now Mr. Chen also brought up things that were being proposed at these meetings. Could you elaborate?
Absolutely. Now, the militant ideas that were being proposed violated state law as well as the school policies as well.
All right, one final question. Why were the students' belongings searched?
Well, the reasons that the students' belongings were searched is because of the previous accusations and the bragging of the hackings of the school computers. Now, as Principal Gomez, she needs to keep the safety and the discipline in the school, and so she needed to search them.
No further questions, Your Honor.
Any recross?
I don't believe there's any remaining. Okay, no recross, Your Honor.
Witness may step down.
Thank you, Your Honors.
At this time, the plaintiff rests.
Defendants, you may call your first witness.
Yes, Your Honor. At this time, the defense calls Jesse Springfield to the stand.
Morning. You may.
Would you please introduce yourself to the court?
My name is Jesse Springfield. I'm a junior at Phillips High School.
And Jesse, who are you here on behalf of today?
I'm here representing myself and the other 4 defendants. We're all members of the group Occupy, but it was decided through a vote that I would speak as a representative for the group.
And could you explain for the court what Occupy is?
Occupy is a group of all different kinds of students at Phillips. For example, we received help from the Health and Nutrition Club and the Political Science Club. And Occupy has basically come together to protest a backdoor deal the school's made with NFC.
So what exactly about this NFC deal does Occupy object to?
As a group, we're really against NFC coming in and branding their name on our school, and also kind of making us buy their unhealthy products during school.
So specifically pertaining to that first concern, what's significant about the branding of NFC's name at Phillips?
Well, as a school, we're extremely proud of the fact that our football field is named Freedom Field, specifically to commemorate our community's veterans. But with this NFC contract, it would change that name from Freedom Field to Fructose Field.
Now, addressing your second concern, what about the unhealthy products at NFC?
Objection, relevance.
Response, Your Honor.
Yes.
This is laying a foundation for the reasons why Occupy is actually going to protest the group itself.
May I respond?
Yes.
I believe that Mr. Springfield has stated that he is against the unhealthiness of NFC's products. However, to elaborate on the specifics of NFC's products is not relevant to today's hearing.
Response, Your Honor?
Sure.
Mr. Springfield simply elaborating on the foundation on which Occupy is protesting. Thus, it is relevant for him to explain this as to show the nature of Occupy's protest and to establish why the group was even protesting NFC in the first place.
The objection is overruled.
May I proceed, Your Honor?
You may.
So, Jesse, what about the unhealthy products is Occupy objecting to?
Through research that was collected by the Health and Nutrition Club, we found out that these products are not only unhealthy, but they've been linked directly to obesity and diabetes.
So after you found out these concerns with NFC, how did Occupy as a group proceed from there?
After this, we set up a meeting with Principal Gomez and the school administration.
And could you explain what happened at that meeting?
I wouldn't even really call what happened a meeting. It was more like getting a lecture from Principal Gomez. You know, she told us that we didn't understand how the real world worked and that it was basically a done deal. You know, they tell us in school that we're young adults and that we have rights, and then they tell us that we have no say in something that affects our entire school.
So given the school's response at this meeting, how did Occupy proceed from there?
Well, we learned in our U.S. history class that in order to make a protest effective, you need as many people as you can to support your cause. So we got on social media. We made a Facebook page, a Twitter account, online petitions. We also made leaflets and flyers as another form of our protest.
Once you took these actions, what types of responses did you see from the community?
The response we got was overwhelming. It was more than we could have imagined. In a matter of days, we had 1,500 signatures on our online petition from a community of people that all oppose this NFC deal.
So, given the response from the community, what did you see in the school environment, Jesse?
The school environment was great. In my opinion, this was the greatest educational opportunity we had been given because we were discussing real issues like this deal, which is what Occupy is all about.
Okay, so given the response from the community as well as the environment in the school, how did the administrators at Phillips respond?
Well, as support for the group was really beginning to skyrocket at that point, that's when the school began to crack down on us.
And in what ways did they crack down, Jesse?
I mean, in what ways didn't they crack down? For starters, they took down all of our leaflets that were around the school, and if that wasn't enough, they began harassing members of Occupy that were handing these out before and after school. And finally, they were censoring Occupy because they refused to publish an Occupy-related article in the school newspaper.
So you mentioned earlier that you're here representing the 4 other defendants of Occupy and your representatives today. Did the school take any additional action with the 5 of you?
Yes, they also issued a warning to us.
What did the warning letter say?
They basically tried to muzzle us at that point. They told us that we would get in serious trouble if we interfered with their deal, that we couldn't meet on school property, and that we couldn't even hand out our leaflets.
So after the school takes these attempts to muzzle the group Occupy, how do you respond to that?
As a group, we were forced into a corner by the school, and we knew that our only remaining option was to take this protest public, so we created Tent City.
What exactly is Tent City, Jesse?
Tent City was kind of like our version of the Occupy Wall Street movement that we learned about in our U.S. history class. We set up tents outside the football stadium as a symbolic form of our protest that the school can no longer ignore.
So did you attend?
Yes, absolutely.
Based on your observations when you were at Tent City, could you describe the environment for the court?
Well, Tent City was really a memorable night because we were out there. We were letting the community know what we felt about the deal. I got a chance to talk to Mrs. Chen about her time in the military. I got to talk to the news, and I got to talk to members of the community. And we saw as a group how firsthand peacefully voicing our opposition could really make a change in the community.
Well, after Tent City, did the school have a response to that?
Yes. When I came to school the next morning, the lock had been cut off of my locker. My personal belongings were missing, and I was ordered to go down to Principal Gomez's office.
Who was in Principal Gomez's office?
Principal Gomez was there along with Casey Sanderson, who I had thought was a student at Phillips.
But who actually was Casey Sanderson, Jesse?
He was actually Casey Mancuso, an undercover police officer working with the school.
Okay, so could you take the court through what happened in Principal Gomez's office with Officer Mancuso and yourself?
Well, the first thing that Principal Gomez did was order Mancuso to search through my backpack like I was some sort of criminal, and it's not like there was anything illegal in the backpack.
After they searched the backpacks, did they do anything with the contents?
Yes, they took some leaflets that I had, along with my cell phone.
What did he do with the smartphone, Jesse?
They asked for my passcode, but I didn't give it to them because no one has the right to invade my privacy like that, especially for no reason.
And just to clarify, what exactly do you have on that smartphone, Jesse?
It's mostly just personal stuff. There was actually stuff that I needed for class that day on it.
Okay. Now, Jesse, I want you to look back at some of the rule violations that Principal Gomez talked about in her direct examination. Were you here for that?
Yes, I was.
Did you hear when she talked about the recognition of authorship on Occupy leaflets?
Yes.
How did Occupy, if they did at all, try to fulfill this requirement?
Well, you see, Occupy doesn't have leaders. We work through a consensus, so all agreements are made on behalf of the entire group. And since the entire group worked on all of these leaflets, we identified authorship by using the name Occupy, which in this case was the author.
And in addition to that, from your observation, did it look like the school actually enforced the rule about authorship?
No. In fact, I see useless leaflets all the time in this school, and they never have an author, and they're never taken down, just ours.
Furthermore, where were these Occupy leaflets produced?
They were all made at a local print shop, which was off-site from high school.
And at what time period did you pass out these leaflets?
We handed them out before and after school.
Okay. Now, Jesse, I want you to look back at the entire course of Occupy's protests as a whole. Were there any instances, to your knowledge, of vandalism by a member of Occupy?
Objection, speculation as to the actions of every single member of Occupy.
Response, Your Honor.
Yes.
I believe the question was specifically phrased so it was based on Mr. Jesse's actual observations. He's not testifying as to every group or every member of Occupy just based on what he observed.
May I respond?
Sure.
The question did call for the actions of any Occupy member, which would ask for Mr. Springfield to testify as to these members' actions.
The objection is overruled.
Yes, Your Honor.
May I answer the question?
Would you like me to repeat the question?
Yes, please.
So, Jesse, based on your observations, were there any instances of vandalism by Occupy members?
From what I observed, absolutely not.
What about, once again, from your observations, violence by Occupy members?
No. Again, the beauty of Occupy is that we were able to voice our opposition without any need for physical violence whatsoever.
Nothing further at this time, Your Honor.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may proceed.
Springfield, my name is Megan Shanklin, and I'll be asking you a few questions today.
Okay.
At school, you've become a member of your group, Occupy, correct?
Yes, I am a member of Occupy.
And in fact, Mr. Springfield, you're a leader of this group by example, correct?
I wouldn't say I'm a leader. Occupy really doesn't have leaders.
You would say you're a leader by example, though, correct?
I guess you could say that, yes.
And in fact, you're actually more active than most members.
I would say that, yes.
And some of Occupy's other active members include Storm Jackson, Alex Leslie, Terry Silva, and Trilby Van Acker, correct?
How so?
As to the multiple different names of each individual Occupy member.
Response.
I can ask them separately.
Let me hear your question again.
I said, some of Occupy's other active leaders include Storm Jackson, Alex Leslie, Terry Silva, and Trilby Van Acker, correct?
The objection is overruled.
Yes, Your Honor.
Would you like me to repeat the question?
Yes, please.
Some of Occupy's other leaders include Storm Jackson, Alex Leslie, Terry Silva, and Trilby Van Acker, correct?
Well, again, I wouldn't call them leaders, but yes, they're members.
Now, Occupy was started in response to Phillips's deal with the NFC, right?
That's correct.
In fact, the first day you heard about this deal, you had a heated meeting at lunch with about 20 other students regarding ways to stop the deal, right?
Well, yes, lunch was our free time.
And you and Occupy started meeting every day in your school cafeteria after that, right?
That's correct.
And through these meetings, you decided to create a Facebook and a Twitter for Occupy, correct?
Yes, and we also made online petitions and leaflets.
Right, and this Twitter had about 300 followers, right?
Yes.
And your online petition had 1,500 signatures?
Yes, we were extremely excited by the response.
And on direct examination, you spoke of an article that you tried to get into the school newspaper. You got this article put online, correct?
It was online, yes.
Now, the school never censored your Twitter, did they?
No, they did not.
The school never censored your Facebook?
No, they did not.
They never shut down your online petition?
No, they did not.
And that article actually got on the school website, right?
Somehow it did appear on the school website, yes.
So all of these outlets of communication are still able to be accessed outside of the school building, right?
That's correct.
All right. Now, as everything progressed, you and Occupy started making leaflets for your protests, as you stated, correct?
Yes, we did.
And you placed these in various locations around Phillips?
Yeah, where flyers normally occurred in the school.
Now, you never showed these leaflets to Dr. Gomez before distributing them, did you?
No, we did not.
All right. At this point, I would like to reintroduce to the court Exhibit A. Please note that I am showing a clean, unmarked copy to opposing counsel, along with a copy of the errata sheet. May I approach the witness?
You may.
Thank you.
Mr. Springfield, can you please tell the court what this is?
These are select provisions from the student handbook.
All right, can you please go to the section titled Non-School Sponsored Publications, and please follow along as I read subclause A under number 3. Anyone wishing to distribute literature shall present a copy to the principal 1 day in advance of its planned distribution. Did I read that correctly?
Yes, you did.
All right, and now please follow along as I read number 4. All persons contributing articles to such publications shall acknowledge authorship of said articles by signing them, and shall refrain from libel, obscenity, and irresponsible personal attacks. Did I read that correctly?
Yes, you did, which in this case we did.
And that was not the first time you've actually seen that rule, correct?
I'm sorry, could you repeat your question?
That's not the first time you've actually seen this rule, number 4, correct?
No, it is not.
In fact, your teacher, Ms. Chen, actually showed you that already.
Yes, she did.
At this point, I'd like to move to introduce Exhibit B to the court. Please note that I'm showing opposing counsel a clean, unmarked copy. May I approach the witness?
May do so.
Mr. Springfield? Now, this is a flyer detailing some of Occupy's concerns, correct?
Yes, it is.
Mr. Springfield, can you please point out to the court where your name is on this flyer?
The name of the author, which was the group Occupy, is written here. Occupy the field.
Mr. Springfield, I'm not sure that you understood my question. I simply asked if you could point out to the court where your name, the words Jesse Springfield, are on the paper.
My name isn't on it. The school rule does not call for student names.
Mr. Springfield, I'm not asking about your opinion on the school rule. I'm simply asking for you to point out your name on the flyer, and you cannot do so, correct?
My name is not on this, no.
How about Storm Jackson's name?
No.
Alex Leslie's?
No.
Terry Silva's?
No.
Trilby Van Acker's?
No.
So, Mr. Springfield, can you point out to the court the name of any Occupy member on that flyer?
Well, as a group, we worked on these together, these students that you named. So in this case, to acknowledge authorship, we used the name Occupy the Field.
So to return to my question, the answer was no, correct?
That's correct.
Now, Mr. Springfield, regarding the rule specifically, could you please turn your attention back to Exhibit A? Now, the rule I just read, number 4, it does say all persons, correct?
Yes, it does.
So, despite being made aware of this rule, Occupy didn't give a single person's name on their flyer, did they?
No, this rule only calls for these persons who contributed to acknowledge authorship, which we did by using the name Occupy.
Mr. Springfield, to clarify, Occupy is a group, correct?
Yes, it is.
Occupy isn't a person, is it?
No, it's just a group of people.
All right, let's go to one last section, the section titled Student Clubs. Can you please follow along as I start reading at Phillips and ending at Publications? Phillips does not permit non-curriculum related student groups to use school facilities for meetings or activities. In order to use school facilities for meetings and special events, student clubs must register and be approved by the principal or her designee and agree to comply with all applicable school rules regarding membership and publications. Did I read that correctly?
Yes.
Now, Occupy never registered as a student group,
Objection,
correct?
Your Honor. Relevance. May I be heard?
Yes.
Specifically in the Board of Education versus Mergen's case, the Supreme Court was faced with a similar decision like this, where a non-curriculum-based group was under scrutiny for their use of school facilities, and that non-curriculum-based group didn't fulfill the procedural requirements of the school district in order to become a curriculum-based group. But in that decision, the Supreme Court put no weight on the procedural requirements, much like in this case, the procedural requirement of applying, and only focused on the substance of the group itself in determining whether or not it was curriculum-based. Thus, opposing counsel using the line of questioning to establish procedural requirements is not relevant in this case, as the Supreme Court put no weight of the evidence on the actual matter in the Mergen's case.
May I respond?
Yes.
This case is not Board of Education versus Mergens. Opposing counsel may argue the connection to Board of Education versus Mergens in his closing argument. However, this questioning about if Occupy ever registered as a student group is simply being used to show the court the facts of the case. He may argue its relevance to it being a curriculum-related group on closing argument.
Response, Your Honor.
Yes.
While I understand this case certainly is not the Board of Education versus Mergen's case, the fact of the matter is that the Mergen's case established the standard for being a curriculum or non-curriculum based group, which is the issue at hand today and which is the issue that opposing counsel is trying to draw from my witness. Thus, it's not relevant today to ask about the procedural requirements, as the Board of Education case actually never put any weight of consideration based on curriculum or non-curriculum, solely based on the actual procedural requirements, simply only on the substantive matters of the group.
May I respond?
I don't think you need to. I mean, that's a proper point to raise on final argument, but for purposes of cross-examination, I think the question is proper. I'm going to overrule the objection.
Yes, Your Honor.
Now, Mr. Springfield, Occupy never registered as a student group, correct?
No, we did not.
Furthermore, Occupy received a notice from the school, right?
Yes, we did.
And that notice stated that you're prohibited from meeting on high school property.
That's correct.
And at a meeting that night, the same night you received that notice, you actually decided to erect your tent city. Isn't that right?
Yes, we decided that we needed to take this protest public.
At this point, I move to introduce Exhibit C to the court. Please note that I'm showing opposing counsel a clean and unmarked copy. May I approach the witness?
You may do so.
Now, this is a map of Phillips School grounds, correct?
Yes, it is.
And can you please point out to the court where your tent city is on this map?
Tent City took place in this, away from the grassy area, which was in front of the football stadium.
So, according to this map, Occupy's tent city is, in fact, on school grounds.
I mean, it was away from the high school, and we did not use the football stadium itself. But I guess you could say technically.
So that's a yes, it was on school grounds.
Yes.
Thank you. No further questions.
Any redirect?
Yes, Your Honor. May I proceed?
You may.
Jesse, do you still have Exhibit A with you on the stand?
Yes.
I'd like to draw your attention to what opposing counsel asked you in cross-examination, specifically Rule Number 4 under school-sponsored, non-school-sponsored publications.
Okay.
Your Honor, let the record reflect I'm referring to Rule Number 4 on the bottom of page 149.
Okay.
And in that rule, Jesse, could you tell the court at any point, does that rule talk about single authors?
Absolutely not. It only states that the persons that contributed need to acknowledge authorship. And since we make all of our decisions as a group, as a consensus, we decided that in order to acknowledge authorship, we would use the name of the group, Occupy.
Objection. I move to strike that answer as improper opinion as to the extent that Occupy was following or not following this rule.
Response, Your Honor.
Yes.
The question simply asks what Occupy did to try and follow the rule itself, not whether or not Occupy, in Mr. Springfield's opinion, actually followed the rule, simply what the group did to try and abide by the school. He's not giving an improper opinion. Pursuant to Rule 701, he's permitted to give opinions rationally based on what he perceives, and since opposing counsel did establish the foundation that he's seen the rules before, he's read them before, he can give an opinion as to how Occupy's flyers themselves are trying to adhere to the rule.
May I respond?
Yes.
Although the question may not have called for an improper opinion, Mr. Springfield did apply his action to the school's rules and thus did draw an improper opinion on how well his group, who he has bias towards, how well they followed this rule.
Objection is overruled.
Yes, Your Honor. Were you finished with your answer?
Yes, I was.
Okay, so could you, is Exhibit B still up there, Jesse?
Yes, it is.
Could you just highlight for the court specifically where in that exhibit you tried to follow the school rule?
Well, like I said, we used the name of the group, who were the authors of these. And at the top it says the name of the group, which is Occupy the Field.
Your Honor, let the record reflect that Mr. Springfield has pointed to the top of Exhibit B, the section where the name of the group is identified.
The record will so reflect.
No further questions at this time, Your Honor.
Any recross?
None necessary, Your Honor.
Okay. Witness may step down.
Thank you.
Does the defense have any additional evidence to present?
Yes, Your Honor. At this time, the defense calls Alex Chen to the stand.
You may proceed.
Would you please introduce yourself for the court?
Yes, my name is Alex Chen. I'm a government teacher at Phillips High School.
And how long have you been at Phillips High School?
Well, I actually graduated from Phillips as a student in 2002, and in 2010 I came back as a teacher.
So what were you doing in the interim between these 2 years?
Well, during this time I served in the U.S. Army and completed 2 tours of duty in Iraq. Afterwards, I took the next opportunity to be honorably discharged and returned to the States.
And returned to the States, what did you do then?
Well, I attended the Ohio State University and received my bachelor's degree in education, and then went on to the University of Cincinnati to receive my master's.
So as a government teacher at Phillips High School, what courses do you teach?
Well, I teach U.S. history and political science as well as government.
And besides being a teacher, do you have any other responsibilities within the school?
Yes, I also sit on the school board that oversees Phillips student groups. So in relation to that, I serve as an advisor to several of these groups, such as Mock Trial and more informally Occupy.
So why did you agree to become involved with Group Occupy?
Well, although I do see some value in an artificial turf field, I believe that the right of these students to express their views is far more important. You know, these are the same rules that we teach them about in schools, the same rights that I personally fought for, and I believe it's extremely crucial that we allow these students to continue to develop these skills.
So how did you actually become involved with Occupy?
Well, I hold these lunch discussions, you see, and I think of these as my own version of FDR's fireside chats. During this time, the students and I gather and we discuss many current events issues, such as civil disobedience in the Arab Spring, and we've also had discussions called What Would Martin Luther King Jr. Do? So naturally, topics like these served as a springboard for discussion into the NFC deal.
So who was involved with these discussions?
Well, Jesse Springfield was a frequent member of these discussions, as well as some other members who would later go on to form Occupy.
Are you familiar with Jesse Springfield?
Yes, in fact, he's one of my U.S. history students, and I would say he's one of my better students, always engaged and inquisitive in class, and particularly interested in corporate power and corporate influence on politics.
Okay. So following these lunch discussions, did you continue to be involved with Occupy?
Yes, I did. In the beginning, I helped coordinate meetings between the students imposed at the NFC deal and the school administration, and afterwards from time to time consulted with the students in regards to school policy, and ultimately attended Tent City as well.
Okay, so you mentioned meetings. What was the nature of these meetings?
Well, there were two meetings. The first was with the principal, and the second one had the superintendent in attendance as well. In both cases, the purpose of these meetings was to allow these students to articulate their position on the NFC deal, and as later their protests would show, to be able to request for public hearings on the matter.
And what was the school's response during these meetings?
Well, unfortunately, the school shut the students down. Principal Gomez told the students that the NFC contract was a done deal, that there wasn't anything they could change at that point.
So following this response from the school, did Occupy take any further action to get their message out?
Yes, seeing as the school was not responding to their concerns, Occupy decided to try to garner support for their cause, to spread their word, just like we've seen in historical movements, such as during women's suffrage. So they started passing out leaflets, posting up flyers and signs, and even creating an online petition as well.
So from your perspective as a teacher, Ms. Chen, could you describe the impact that Occupy's protests had on the environment of the school?
Well, as the NFC deal was a controversial issue, naturally students did form sides, and there was some tension and dispute, but nothing of a major degree of distraction, I would say.
And did this tension ever affect your classroom teachings?
Well, I do recall one instance in which the students, early on when the group was just forming, did get off track discussing protest activities, but even then I was able to draw the students back to the original discussion at hand.
And was that the only time Occupy was ever brought up in your class?
Well, as civil disobedience is a part of my classroom curriculum discussion, naturally Jesse and some other members of Occupy did from then on often tie classroom discussion to Occupy's activities. But as a teacher, I actually see that as extremely encouraging, to know that my students are able to take what they learned in class and apply it to their own lives.
Okay, so based upon your observations, did Occupy's protest ever result in violence in the school?
From what I saw, I do not believe so, sir.
Did you observe any destruction of property from these defendants?
No, sir, I believe not.
Did you observe any physical altercations?
No, sir.
Okay. So following Occupy's protest, then did the school respond?
Yes, in fact, the school came down pretty heavy-handed on these students at once. The school started taking down Occupy's flyers and signs, added additional surveillance around the school, and I tried to request for another meeting for the students with the principal, but unfortunately was denied this request. Later on, I then learned that the school sent out a warning letter to some of the members of Occupy as well.
So specifically following this warning letter, then, did Occupy continue their protests?
Yes, after several failed attempts to reach out to the school administration, Occupy decided next to take their protest public, and did so through their symbolic demonstration of opposition to the NFC deal, known as Tent City.
Okay, so you earlier mentioned that you attended Tent City. Could you describe the layout for the court?
Yes, Tent City was set up on the grass, is set up on the grass north of the football stadium, and it's actually set up sort of like a military bivouac site. When I first attended, there were about 10 to 12 tents with 40 or so protesters in all.
And based on your observations, could you describe the environment at Tent City?
Well, Tent City was incredibly calm and peaceful when I attended the event. Students there just interacted with one another in a calm manner and with other members of the community that happened to attend as well. In fact, some of the students just did their homework while they attended the event.
And while you were there, did you ever engage with any of the students?
Yes, I had the excellent opportunity to sit down and have a discussion with some of the students about how Tent City echoed the historical protests we've seen in our nation. For example, the civil rights sit-ins.
And during the time that you were there, did Occupy take any action as a group?
Well, there were ground rules set forth at the event, and these were the same rules that were set forth at the Occupy Wall Street movement. So the rules were along the lines of no violence, no drugs, no alcohol, rules of that nature.
And to the best of your knowledge, were these rules ever violated by Occupy members?
From what I saw, absolutely not. I'm actually extremely proud of my students and how they conducted their demonstration.
So earlier, Ms. Chen, we heard from Principal Gomez about school policy concerning the usage of Tent City grounds, the grounds upon which Tent City occurred. Are you aware of this policy?
Yes, there are actually two policies governing this area. One in regards to curriculum versus non-curriculum related groups, and the second in regards to access to the field and the surrounding grounds.
No, Ms. Chen, do you still have Exhibit A as well as the errata sheet in front of you?
Yes, I do.
So are you familiar with the policy concerning curriculum and non-curriculum related groups?
Yes, as I am on the school committee board.
So what's the distinction between a curriculum and non-curriculum related group?
Well, curriculum-related groups have the benefit of access to school facilities for their events and functions.
And how does one become a curriculum-related group?
Well, there are actually several methods that one can use, but in this case, I believe the one that would most qualify would be the qualification that the group itself has to essentially be an extension of class discussion and cover material that is taught in that class.
So in your opinion, based upon your observations of Occupy, would they fall into the category of curriculum-related?
Well, absolutely.
And why is that?
Well, Occupy's protest activities were essentially born through my class discussions. If you take a look at, for example, their protest activities, their demonstrations, their methods of garnering support, their actions parallel similar actions that were taken in history during historical protests we've seen, such as the Vietnam War protests, civil rights movement, women's suffrage, or even the more recent Occupy Wall Street movement.
So you also mentioned a second policy concerning the stadium grounds specifically. Could you elaborate what that policy is?
Yes, that policy is a general policy that states that anyone can have access to the football field and surrounding grounds as long as there are no events scheduled on that night.
And the night Tent City occurred, were there any other school events scheduled?
No, there were none.
So looking back on Tent City then, did Occupy's usage of those grounds for Tent City violate any school policy?
Well, I do not believe so. I mean, Occupy meets the spirit, the essence of what a curriculum-related group is all about. And even if we disregard this rule, the general policy states anyone can have access to the football field if there are no events scheduled. So in that respect, Occupy did not violate any rules.
No further questions, Your Honors.
Any cross-examination?
Yes, Your Honor.
May I proceed?
You may.
Good morning, Ms. Chen. My name is Ariana Cerquera, and I'm going to be asking you a few questions today. All right. So you're pretty familiar with Jesse Springfield, seeing as he's one of your best students, correct?
Yes, that is correct.
And you've become somewhat of an informal advisor to his group, Occupy?
Yes, ma'am.
And being the informal advisor, you could say you know quite a bit about Occupy, right?
Yes, I would say so.
So let's talk about Occupy's actions. Occupy did post flyers around the school, correct?
Yes, that is correct.
And Occupy engaged in protest activities?
Yes, I believe they did.
And their protest activities occurred both in and around the school?
That is correct.
And the school was tense, wasn't it?
Yes, as I stated earlier.
And students began to take sides on this issue?
Yes, as the NFC contract was a controversial issue.
All right, and students would argue with each other in the hallways about this issue?
You are correct, ma'am.
And some students would interrupt Occupy meetings in the cafeteria?
That is correct.
And all anyone wanted to talk about in class was Occupy, the NFC, and the stadium deal?
Yes, those three topics.
And didn't Jesse and other students use every possible opportunity to tie the class discussion to Occupy activities?
Yes, as I stated before, I really do see that as encouraging as a teacher.
So that's yes.
Yes, that is correct.
So at this time, I'd like to introduce Exhibit A. Does the witness actually already have a copy?
Yes, I do have a copy.
All right, so could you please tell the court what this is?
Yes, Exhibit A is select provisions of the Phillips High School Student Handbook.
And could you follow along as I read from page 150, starting under student clubs? Phillips does not permit non-curriculum related student clubs to use school facilities for meetings or activities. In order to use school facilities for meetings and special events, student clubs must register and be approved by the principal or her designee and agree to comply with all applicable school rules regarding membership and publication. Did I read that correctly?
Yes, you did.
Yet you claimed that school policy allows all students access to the field and no events are scheduled, right?
Yes, that is a general policy that's been put into practice at Phillips.
However, I did just read that rule correctly, didn't I?
Yes, you did.
So according to the school Phillips policy that I just read, you need to be a registered curriculum-related group to use school
Objection, Your
facilities.
Honor. Relevancy may be heard.
Yes.
While I understand the court's previous ruling concerning the Board of Education versus Mergen's relevancy to this particular instance, I would like to re-raise the objection to preserve the record.
Any response?
Your Honor, my opposing counsel can argue the relation to Board of Education versus Mergens on his closing.
Yeah, the record will reflect your continuing objection to that regarding this, your objection to this testimony. The objection will be overruled.
Yes, Your Honor.
Thank you. May I ask a question again?
Yes.
So according to the Phillips school policy that I just read, you need to be a registered curriculum-related group to use school facilities.
Yes, that is correct.
Right. And in order to be considered an official student group, you need to apply, right?
Yes, to be recognized by the school.
And in order to apply, you must be approved by the principal?
That is what it states, yes.
And the group must draft a constitution?
That is a rule that is put into practice.
Right. And you must elect student leaders?
Yes.
And Ms. Chen, you are on the committee that oversees official student groups, right?
That is correct.
So you were aware of these rules at the time you met with Occupy?
Yes, I was.
And you explained these rules to them?
I did, at an after-school meeting I attended.
Yet, to this day, to your knowledge, has Occupy ever drafted a constitution?
No, they did not actually agree with all of the requirements, such as drafting a constitution.
And they've never elected leaders, have they?
No, they felt it did not best represent the group.
So then no?
Yes, that is a no.
And Occupy has never been approved by Principal Gomez?
That is correct.
And in fact, Occupy never even applied to be considered a registered curriculum-related group with Dr. Gomez. Isn't that right?
That is correct.
All right, so let's talk about you. You're only allowed to advise registered curriculum-related student groups, correct?
Yes, as a formal advisor.
And Principal Gomez had requested that you bring any prohibited activity by Occupy to her attention, correct?
That is correct.
And this prohibited activity included meeting or distributing literature on school property, right?
That is correct.
And you had seen Occupy students copying flyers?
I had seen them do so, yes.
And you had seen Occupy students then posting their flyers on the school walls?
That is correct.
And you had seen these Occupy students meeting in unused classrooms when they weren't supposed to?
Yes, only in unused classrooms, however.
However, when they were not supposed to, correct?
That is correct.
All right, now Ms. Chen, you are in school roughly 5 days a week, right?
Yes, that is correct.
Roughly 8 hours a day?
Yes, I would say so.
Yet, with all of this time you had, you never notified Principal Gomez about these prohibited activities, did you?
Yes, I was unwilling to assist a school administration that was unfairly targeting these Occupy students.
That's not my question. You never notified Principal Gomez at any point about Occupy committing these prohibited activities, did you?
That is correct.
All right. And just to clarify, your teaching contract requires you to enforce leaflet and facilities rules against non-registered student groups?
That is correct.
So, therefore, you broke your own teaching contract, didn't you, by not enforcing the leaflet and facilities rules?
Yes, I did not want to participate and assist the school in doing so.
So that's a yes. You broke your teaching contract?
Yes, that is correct.
Thank you. No further questions, Your Honor.
You redirect?
Yes, Your Honor.
You may.
Ms. Chen, do you recall opposing counsel question on cross-examination concerning the debates in the hallways of Phillips High School?
Yes, I do.
Based on your observations of these debates, did they disrupt the school environment?
Not that what I recall. The NFC controversy was, as I stated, a big issue, so naturally there was some dispute, but it never resulted in a major degree of disruption.
And do you recall opposing counsel's question regarding these protests in relation to your classroom?
Yes, I do, sir.
Did Occupy's discussion ever affect your classroom in a negative way?
Overall, there was no negative impact. I only recall one instance in which I had to even steer them back into the original discussion.
And besides that one instance, can you describe how Occupy's discussions affected your classroom?
Well, as I stated earlier, I find it extremely encouraging that my students can take what they learned and apply to their own lives. And so I actually would enjoy seeing that they are able to do so and be able to contribute to class discussion in this manner.
No further questions, Your Honor.
You recross?
No recross, Your Honor.
Witness may step down.
That's stressing this time, Your Honor.
Okay. At this time, we'll take 2 minutes so that counsel can prepare your closing arguments. If the timekeepers would keep track of that for me, I'd appreciate it.
Ohio High School Mock Trial Championship coordinated by the Ohio Center for Law-Related Education. We are at the State House in downtown Columbus. I'm Stephanie Bucher with the Supreme Court of Ohio. Right now, the students have just a couple of minutes to get ready for their closing arguments in the case Phillips School District versus Jesse Springfield. Orange High School has been arguing for the plaintiff, Phillips School District, and it will argue that its temporary restraining order against the protests should be granted and that it did not violate the students' First and Fourth Amendment rights. Sylvania Southview High School, arguing for the defendant, Jesse Springfield, has been arguing that the students' First and Fourth Amendment rights were violated and that the school district's temporary restraining order should be denied. After our teams deliver their closing arguments, the judges will adjourn for a short time to deliberate, during which time I will have a chance to talk with some of these students who've been participating today. When the judges are finished, our coverage will continue as they give comments and announce our winning team. Right now, let's go back to the floor as we hear our closing arguments.
You may.
May it please the court. As my co-counsel stated, there is a time and a place for everything. As we saw today, Occupy's 10th city protest is at neither the proper time nor place. Your Honors, today we have proven two things. One, that all four factors necessary to granting Phillips's temporary restraining order have been satisfied by both clear and convincing evidence. And two, that the defendants have failed to prove even a substantial likelihood of success on the merits of their claims, and thus their TRO should be denied. As for Phillips's TRO, we have demonstrated that Phillips does indeed have a substantial likelihood of success on the merits that Occupy is not a curriculum-related group and thus is not entitled to access school facilities. In Board of Education versus Merchants, the Supreme Court upheld that a group is not curriculum-related if it has as its purpose the advocacy of partisan, theological, political, or ethical views. Your Honors, partisan political views are the basis of Occupy's existence. You heard Jesse Springfield come to the stand today and argue for Occupy's political opposition to the NFC and its deal with Phillips. Thus, Occupy is unquestionably non-curriculum related. Furthermore, you heard today how Occupy was a constant disruption to the school day in both the halls and the classroom, testified to by Dr. Gomez, Alex Chen, and Casey Mancuso. Phillips's actions today are rooted in its school handbook, the Equal Access Act, and pertinent Supreme Court precedents. And the Equal Access Act explicitly does not limit a school's authority to maintain order and discipline on its premises. Because it is non-curriculum related and because of its excessively disruptive nature, Occupy is not entitled to access school facilities like the grounds that its tent city is currently standing on. Your Honors, Phillips High School will undoubtedly suffer irreparable harm if this restraining order is not granted. Not only did Dr. Gomez testify to the importance of the $500,000 deal with the NFC and the safety improvements that it could bring, but she also stressed that providing education to the students is Phillips's main objective. If Occupy continues with its disruptive actions, it will inflict a level of harm on both the school and the students that can never be undone. Now, on the other hand, granting this motion will cause no harm to any of the members of Occupy. As you heard from Jesse Springfield, Occupy was never limited in using the internet for communication of its ideas. Furthermore, there has been no testimony whatsoever suggesting that Occupy was ever limited from protesting in public places outside the school. Because these alternative means are available, it is apparent that the defendants will not be restricted in the communication of their opinions. As for the defendant's own TRO, we have demonstrated that there has been no unconstitutional restraint on the student's freedom of expression under the First Amendment. As Dr. Gomez testified, it was the time, place, and manner of Occupy speech that called for the enforcement of school rules, not its content. Thus, Occupy speech was indeed open to Phillips's reasonable time, place, and manner restrictions as per the guidelines set by Clark versus Community for Creative Nonviolence. To the claim of the Fourth Amendment violation, the Supreme Court in New Jersey versus TLO established that the legality of school searches does indeed depend on reasonableness. Reasonableness is determined by whether the search was justified at its inception and whether the scope of the search was reasonable under the circumstances. The locker and backpack searches in today's case were indeed justified at inception, as the students had broken countless school rules. You heard this today from Dr. Gomez, from Alex Chen, but most notably, Your Honors, from Jesse Springfield himself. Furthermore, the search was justified in scope due to the fact that following Detective Mancuso's undercover investigation, he had reasonable suspicion that Occupy was planning to break more rules and potentially laws. Your Honors, there is a time and there is a place for everything. On school grounds, during school hours, is simply not the time nor the place for the non-curriculum-based group Occupy to conduct their disruptive protests. Therefore, the plaintiff respectfully requests that the court deny the defendant's motion for a temporary restraining order and grant the motion of Phillips. Thank you.
Thank you. Defense counsel, you make your closing argument.
May I proceed?
You may.
In opposing counsel's, may it please the court. In opposing counsel's opening statement, she talked about the need to satisfy a healthy and safe learning environment. But in fact, the most integral part about that learning environment is the ability for students to express their beliefs, to express their ideas. In the words of Supreme Court Justice Brennan, our schools are to be the marketplace of ideas. And with all due respect to opposing counsel, the school is always the time. The school is always the place for this exchange of ideas and for this marketplace, because that's what creates the future leaders of this nation. But despite that, the school today is trying to stifle this, stifle the marketplace and stifle the learning process. When we examine the four elements of a temporary restraining order today as established by the Coleman versus Wilkinson case, we'll start with the very first, substantial likelihood for success on a trial of the merits, and our burden today is through clear and convincing evidence. But when we apply it to the First Amendment rights at hand, whether you're looking at the plaintiff's motion to enjoin tent city or the defense's motion to maintain our leaflets, the law remains the same. The plaintiff has failed, first, because they failed to prove insubstantial and material interference in the school. Because while Principal Gomez wants to testify to the disruptions that are present, look at the actual testimony of individuals who were present at the school, like Officer Mancuso, Ms. Chen, or Jesse Springfield, who testified that there was no violence, that there was no vandalism. Most of all, Officer Mancuso never made a single arrest or noted any specific actions of illegal activity. Tent City has been standing for 2 weeks. During that course of time, Principal Gomez has not received a single complaint about any instance of a violation of school rules or the law. In fact, it mirrors the symbolic speech that was protected under the Tinker versus Des Moines case, much like the armbands that the students had on themselves. Second, the plaintiff has failed today in their application of the Clark versus Community case, because while they are entitled to reasonable time, place, and manner restrictions, those are only possible if the application is content neutral. But that's not what happened. Principal Gomez never took action against the Occupy students until the corporate influence of Lee Martin pushed her to do so. She's trying to shut down Tent City. She tore down the leaflets. She shut down the newspaper article, not because of disruptions, but because of the message of Occupy, and inherently is not content neutral. And finally, under the Board of Education versus Mergen's case, the Supreme Court put no weight on the procedural requirements that the plaintiff wants to argue today, but rather simply on the substantive aspects of the group. And Ms. Chen told you today that Occupy is curriculum-based because they stem specifically from a regularly taught course that's offered at Phillips High School. And finally, applying this first element to the Fourth Amendment, the unreasonable search and seizure of the students' belongings under the New Jersey versus TLO case, schools do have the right to search students' belongings if they have a reasonable suspicion of violations of the law or school policy. But the school had nothing more than a hunch, nothing more than an idea of what they thought was going to be in the backpacks, closed, personal belongings that they couldn't see into. And they found no evidence linking any case of vandalism to Occupy, any incidents of hacking to Occupy, and they're trying to justify their search just because they found a few leaflets that the students had produced and had them with them on their persons. Next, if we move to the element of irreparable harm, the argument for this element, as well as the prejudice to third parties, is essentially the same. Opposing counsel talked about the irreparable harm in the form of $500,000, but that in its very nature is not irreparable. But look instead to the defendants today. The school is trying to stifle their creative ability in that marketplace of ideas, and the loss of freedom of speech for a single minute, for a single hour, for a single day, that's incalculable to the students. That can never be repaid back to them, whereas the school's irreparable harm, the prejudice simply lies in a dollar amount that can be repaid back to them. And finally, Your Honors, if we apply the final principle, which is that of public interest, the final element of the temporary restraining order, becomes clear based on the petitions of Occupy, based on the community support for this opposition against this backdoor deal, that the community supports Occupy. But in addition to that, throughout the precedents, as Ms. Chen talks about in her history class, whether it's the civil rights movement, the women's suffrage movement, or the protests against the Vietnam War, time and time again, history has shown that we protect the voices of the minority, the voices of the daring individuals who dare to stand up and voice their opposition against oppressive bodies that are trying to constrict them. So, Your Honors, today we ask you to rule in favor of that marketplace of ideas. We ask you to rule in favor of the defendants today, to grant this temporary restraining order, to preserve that marketplace, because the school is a time and is the place for the protest activities to occur, because there's been no disruption, but rather it's the place for these marketplace of ideas and these robust exchanges to occur. Thank you.
Thank you. Plaintiff's counsel. You may.
Your Honors, opposing counsel came to the stand today, and they told us a story. They told us the story of a greedy principal motivated by a corporation that went out to violate students' rights because she didn't like what they had to say. They equated today's case to Supreme Court case Tinker versus Des Moines. In Tinker, the Supreme Court ruled that a school could not ban students wearing of armbands based on the absence of evidence that any of these armbands disrupted the school day. But Your Honors, that is not the case we have at hand. As you heard today from almost all of the witnesses called, Occupy's flyers and activities did disrupt the school day. Occupy's flyers violated school rules. Occupy's actions blatantly went against the school handbook, and this disruption and handbook violations are what make Phillips's actions not in violation of the First Amendment, like in Tinker, but basic time, place, and manner restrictions. Furthermore, these handbook violations and this disruption are the irreparable harm in today's case to the plaintiff. The irreparable harm is not the dollar amount. The irreparable harm is a disruption to the learning environment that will ensue if the students continue with their protests. Furthermore, opposing counsel argued today that Occupy was somehow curriculum-related. But despite what Ms. Chen, a teacher who openly admitted to violating her teaching contract, tried to say, nowhere in her classroom could you open a textbook to find the NFC's deal with Phillips. This group clearly fails the Mergens test. Furthermore, Occupy didn't even attempt to register with their school to be curriculum related. Opposing counsel attempted to say that this didn't matter, but the fact is that not registering and then having this tent city was in blatant violation of school rules. And the question is, if Occupy was so certain that they were a curriculum-related group, why didn't they just attempt to apply to register? Thank you.
Thank you. At this time, my colleagues will retire to begin deliberating on their scores. I will remain on the bench for 3 minutes, during which time any protest or objection may be brought to my attention by a team attorney. The team attorneys may communicate with all performing team members involved in this actual round, but may not communicate in any way with legal advisors, teachers, or anyone outside their performing team members. Feel free to use the 3 minutes. If at any time during the 3 minutes you decide that you don't have any post-trial objection, you can simply indicate it at that time.
Your Honor, the defense has no post-trial objections.
Okay.
Your Honor, the plaintiff has no post-trial objections.
Okay. Thank you.
The 2014 Ohio High School Mock Trial Championship on the Ohio Channel. We just heard closing arguments for the mock trial case, Phillips School District versus Jesse Springfield. And right now the judges have retired to do their scoring. And while they do that, we're going to have the opportunity to hear from Lisa Eshelman and get her take on the students' performance. Lisa, thanks so much for rejoining us. What were your overall impressions as you heard the two schools today make their arguments?
This was an incredible championship round. These students were exactly what we had hoped and anticipated. They were polished, they were confident, they knew this case inside and out, and I would put them in a courtroom with any practicing lawyer in the state of Ohio. It was a fabulous, fabulous day.
I made a couple of observations as I was watching the arguments of our two schools. Very polite. Is that a normal thing that you will see not only in mock trial but in real trial?
It is. It is part of the respect for the court and the respect for the rule of law. And so these students have been taught and have learned that when I'm talking to the bench, when I'm asking questions or raising an objection with respect to a piece of evidence, I do it in a very professional, very calm, and very respectful way.
All right, so let's summarize again a little bit about the school's arguments, if you could kind of encapsulate what they talked about today.
Certainly, there are two strong arguments in this case. The first one is centered on the First Amendment of the Constitution, and it really is what's the proper scope of a student's First Amendment rights within the schoolhouse framework. In this case, the students are saying that the school has infringed upon their First Amendment rights by putting in cameras, by policing their flyers, and restricting where they can put the information up. The school, on the other hand, says we have the right as educators to put appropriate parameters around a student's free speech. Then the second one is the Fourth Amendment, and that's the one with respect to what's the proper scope of a school's right to go in and do a search of a school's locker, a student's locker, their backpacks, or any of their materials. In this case, obviously, the plaintiffs are saying it was impermissible for the schools to search the lockers to look for the pamphlets and the materials. And the school is saying we had to. We didn't know what was on hand. We didn't know where this was going. And that's within our right to control the school for safety reasons, amongst others.
When they started the research to put together their arguments, basically they had like a case study. They just had kind of a general thing to go off of. From there, then they built their case?
The materials provided by the Ohio Center for Law-Related Education includes a brief for both the plaintiff and a brief for the defendant. That contains the law. That contains all of the case materials. The legal research is all prepared and given to the students. They also, within those briefs, there are references to the most significant Supreme Court cases. And the students are limited to using those materials as they prepare their legal arguments for the mock trial.
Right. But the other things that came up during the trial, like the objections, that comes directly from the students?
It does. As we talked about before the trial began, part of what the scoring judges are going to be looking for is the mastery of trial procedure. So we saw students stand up, and when they say object, they were looking for what's the basis of that objection. That's when you heard, I object because it's hearsay, or I object because it's asked and answered. So you raise the objection, you tell them why you think it's an improper piece of evidence, and then the other side has the opportunity to respond. And we saw that both today as well.
They also provided some exhibits. Was that part of the material that you gave to them?
It is. We provide exhibits, and part of the trial procedure and practice is, do I lay a proper foundation for that? Do I know the procedure for getting that piece of exhibit into evidence? And we saw the students do that just fabulously today.
So the judges are going to have a very tough decision, I would think. What about you? Do you think that that's going to be a difficult decision for them? What are they talking about right now?
Well, first of all, I'm grateful that I'm not back there trying to make this decision, because I believe it's going to be down to the wire. When we have students at this level of the competition, we're talking points. We're talking just matter of points. They're going to be, the judges in the scoring room today are looking at exactly what we talked about before, the mastery of the law, the mastery of being able to put the application of the facts to that law, trial procedure, and then just their presence and their ability to ask questions and respond to questions. Also, we have the roles of the witnesses. You know, the witnesses who testified today are part of that scoring process as well. So the judges are back there talking about the persuasiveness of the witnesses. What are the witnesses' mastery of the case? You know, do they know the facts and their role in the whole, and how do they respond to the questions both on direct and cross-examination?
Well, it'll be exciting to find out how the judges decide to score on all that, because the kids did a great job. And, of course, the Ohio Center for Law-Related Education did a great job for 31 years putting together this mock trial competition.
Well, we're very, very fortunate that we have an incredible group of volunteer lawyers and judges who every year devote countless hours to creating the fact patterns upon which the case is based. They write every witness statement. They do all of the research. They write all of the briefs. They put all of those materials together. And quite frankly, we couldn't do it without them. Today, our volunteer judges who are serving on the panel, they play such a critical role in everything that we do. So we're very, very grateful.
Wonderful. Thank you so much, Lisa.
Absolutely.
And as we learned earlier from Jared Wrights, the program director of the Ohio Center for Law-Related Education, each of our judges today came together to volunteer their time for this high school mock trial competition. So let's learn a little bit about each of those judges. Steve Tilson is president of the Ohio State Bar Foundation. He practices law in Galion, Ohio, with the firm of Hottenroth, Garverick, Tilson, and Garverick. He graduated from Delaware Hayes High School, received his bachelor's degree from Ohio Wesleyan University, and his law degree from the Ohio State University. Tilson is active in many bar associations and committees, again, especially in the Crawford County area. Jonathan Hollingsworth is president of the Ohio State Bar Association. He received his bachelor's degree from Harvard University, his Juris Doctorate from the University of Michigan, and he's been in practice of law for 29 years, including many of those with the firm Porter, Wright, Morris, and Arthur, and in the most recent years in his small firm setting out of Dayton. He is the past president of the Dayton Bar Association. Presiding Judge Jerry McBride is a graduate of the University of Cincinnati, where he earned a bachelor's degree and master's in public administration. He's a judge for Claremont County Common Pleas Court, previously a judge for municipal court. Judge McBride was also a county commissioner in Claremont County. He is a member of the High School Mock Trial Competition Committee. And Judge Deborah Osbaugh is the administrative judge of the Family Court in Marion County Common Pleas Court. She received her Bachelor of Science degree in Business Administration from The Ohio State University and her Juris Doctorate from Ohio Northern University. Judge Osbaugh began her legal career as a clerk for the Law Aid Society of Columbus. She opened up a private practice. She serves as Marion County Mock Trial District and Regional Coordinator. So those are your judges for the 2014 Mock Trial Championship. Now let's hear from some of the students who participated today. And if you would please introduce yourself and the school that you are actually representing today.
Sure. My name is Chen. I am a senior at Sylvania Southview High School. And
you were part of the defense team?
Yes, we represented the defense on behalf of Jesse Springfield today.
All right, so how do you think it went?
Well, obviously, when you get to the state finals, it's a very close round, so I guess we'll wait to see the results.
Okay. Anything that surprised you during this final of this competition? Because you guys have presented, you went through the district, you went through the regionals, and then you had the state finals where you've already presented this in the last couple of days. How do you think it went in comparison to all of those other times?
Obviously, Orange is a very, very good team. We've been kind of prepared for this, though, because we've been doing a lot of preparation in the long run. Our coaches have done a really good job of preparing us to try and make sure that we're not surprised by anything. But, of course, each team's interpretation of the materials and everything is also unique. So there are some nuances about the trial that do surprise us a little bit. But I think participating in the state competition has been good practice for us in the long run.
Right. So if you go on to the national championship that's going to be coming up in a couple of months.
Fingers crossed.
Are you going Yeah?
Yes, we will. Hopefully, if that does happen, we will be participating in that.
Okay. And how many teams did Sylvania Southview have? You had altogether competing?
We had a total of 4 teams. All 4 of them made it to regionals, and then 2 teams advanced from regionals to the state competition.
All right. Well, good luck. We can't wait to hear what the judges have to say about your performance today.
Thank you so much.
Good luck. Thank you. All right. And now we're going to take a quick talk with someone from the Orange High School, because they're all wearing green. Orange is wearing green today, so we appreciate your time. If you would, please introduce yourself and what school you are.
My name's Ariana Cerquera, and I go to Orange High School.
All right, and you were presenting on the plaintiff side for the Phillips High School District. So what did it take to get ready for today?
I was so nervous that I couldn't even think of anything this morning. So I was just kind of trying to be calm all morning. But then I got in there and I wasn't even nervous anymore. I just did it. So much.
No nerves. You were all set to go?
I was more nervous at districts, and I was in the state championship and I was fine. So
what about your team? What did it take to kind of all come together and prepare for this type of competition?
Well, we're all good friends, so we get along really well, and we practiced 4 times a week, every week, 2-hour practices, so we put in a lot of hard work. So it definitely paid off.
Yeah. And I've heard the comment that you students could be taken to any real trial at any time and present your arguments before a real panel of judges. That's high praise.
It is. I hope it's true. They say that at the end of every trial, and I hope it's true. Good to know for the future.
All right, Ariana, good luck. Thank you so much for talking with us today.
Thank you so much.
All right, so let's talk to the man himself, Jesse Springfield. Of course, obviously, if you step on up, I won't bite, I promise. And let's give your real name and what school you go to.
I'm Zach Pocheka, and I'm a sophomore at Sylvania, Southview.
Okay. And Jack, is this the first time that you've participated in mock trial?
No, this is actually my second year.
All right. So this is a completely different case than what you had to present last year. What did you think about the experience this year in your second year?
Well, I feel like this case was a lot different, but I feel like the first year really prepared us a lot better, so I wasn't as nervous going into this year.
All right, so a little less nerves happening.
Yeah.
Yeah. What about the other team? How do you think everyone kind of compared?
Well, the other team was phenomenal. I mean, obviously it was a very close round, but we've went up against a lot of good teams at state so far, so we're just lucky to be here at this point.
All right. So while you didn't get to present a legal argument, you had to kind of get into character. What did it take to become Jesse Springfield?
Well, actually, I love playing witnesses because you have to really get into the character and think what this character would be thinking. So it's a lot of work, but it's fun.
All right. Well, good luck, and
Thank you.
We'll certainly find out very soon what the judges think about the competition today.
Okay.
Thank you. Well, as you know, we talked earlier about the room that we're in. It's the hearing room for the Ohio Senate. The Senate building is connected to the Ohio State House through the atrium, which was constructed in the 1990s. These three buildings, the State House, the Senate building, and the atrium, comprise Capitol Square. Since we're coming to you from such a historic location, we thought we'd take a moment and learn a little bit more about these buildings. The Ohio Channel's coverage of the 2014 Ohio High School Mock Trial Championship will resume in a few minutes.
The Ohio State House was completed in 1861 at the beginning of America's Civil War. The State House is considered to be one of the most significant architectural accomplishments in the early Republic. Its Greek Revival Doric architectural details and proportions give the impression of permanence, elegance, and grandeur deserved by the original state legislature, who passed a law on January 26, 1838, to build the new State House. Restored to its 1861 appearance, the Ohio State House maintains its historic character as it continues to function as the center of state government in Ohio. The Ohio State House is situated on a 10-acre parcel of land that was donated in 1812 by 4 prominent Columbus landowners. The State House is upon foundations 18 feet deep, built in part by prisoners sentenced to labor. The State House features a central recessed porch with a colonnade of a forthright and primitive Greek Doric mode, built of Columbus limestone that was quarried on the west banks of the Scioto River. A broad and low central pediment supports the drum-shaped cupola, which contains a skylight that lights the interior rotunda. Unlike many U.S. state capitol buildings, the Ohio State House owes little to the architecture of the United States Capitol. It was designed and built before the U.S. Capitol was enlarged to its present form, with a large white dome that would become ubiquitous on government buildings in America. The Ohio State House has been termed a supreme example of Greek Revival style because the city-states of ancient Greece were the birthplace of democracy. This style had great meaning in the young American nation. Greek Revival is simple and straightforward and looks nothing at all like the Gothic Revival buildings popular in Europe at the same period. The broad horizontal mass of the building and the even and regular rows of columns resemble such buildings as the Parthenon in Athens. No ancient Greek building would have contained windows, but they were a major part of Greek Revival for a more practical reason. Before the electric light bulb, sunlight was the major source of illumination. More than a century and a half old, the Ohio State House has been designated a National Historic Landmark by the Secretary of the U.S. Department of the Interior. This honor recognizes the long history of the building and the continued role it will have in the life and lawmaking of the state of Ohio.
Surrounded by brilliantly white marble, you are standing in one of the most impressive spaces in the Capitol Square complex. It is enclosed by a ceiling of detailed murals which surround a stained glass Great Seal of Ohio skylight. Before the massive renovations during the 1990s, it was not known that there was a skylight in this space because it had been covered from the inside and outside with pieces of plywood. Restorers speculate that the skylight had been covered because it was in such a state of disrepair that it leaked and might possibly fall out. It has since been repaired and secured. As you gaze upward, you'll notice the murals on the ceiling of the Grand Stair Hall. These 4 murals represent art, justice, manufacturing, and agriculture. Each painting shows a woman holding various related objects. Also used for decoration in the Senate building is gold and aluminum leafing. Although the gold leafing appears to be quite prevalent, there are only slightly more than 3 ounces of gold in the building. Today, the Senate building is home to 31 of Ohio's 33 senators. The Senate President and Senate Minority Leader both have offices in the State House.
I hope you enjoyed that virtual tour, and you can find many more State House tour videos at ohiochannel.org and also on iTunes by searching for Capital Ohio. Well, we snagged a few more students, and they're going to be talking about their experience. And if you would please give us your name and what school you are with.
Okay, my name is Shivangi Bhatia, and I'm with Orange High School.
All right, and so you were not actually on this team, you were in the audience. So what role were you prepared to do?
Well, I was prepared. I'm actually an attorney on the defense side, so depending on the coin flip, it decides which side goes. So today, I didn't really know what was going to happen, but our plaintiff won, so I was observing today.
Okay.
Yeah.
But you did get to participate through the state final competition at one point to do that.
Yes. Yesterday, we actually participated for the Final Four. So yeah.
All right.
Yeah.
So what do you think of your teammates? How did they do today?
I think they did amazing. I'm really proud of my team. We've come so far and we've worked so hard, and I'm really proud of everything we've accomplished. Yeah.
Right. And you're a senior?
Yeah.
And how many years have you been participating in mock trial?
4 years actually. So I started as a freshman. Mm-hmm.
Right. So how has it progressed for you when you first started as a freshman to now that you're a senior? How has this participation in this kind of competition helped you?
Well, the cases have gotten longer, definitely. So the statements have increased. So we've had to put in a lot of more hard work and time and effort into everything, which is well worth it. And I think we've all become really dedicated to it. We started in the beginning, and now we're just so into mock trial, and it's we love to do everything related to mock trial. Yeah.
It's a lot of fun.
No, it is. It really is. Yeah. Mm-hmm.
Okay, great. Well, thank you
so
much. I appreciate it.
Thank you.
Yeah, well, come on in. We'll talk to another orange who's wearing green. Excellent. Thank you so much for coming over.
No problem.
Give your name, please.
I'm Amy Wu. I go to Orange High School, and I represent the defendants normally.
Okay, so you were also in the crowd watching the other students. So what's your assessment of today's competition?
I thought today's competition was really great. I thought it was a very close trial. I'm really proud of my teammates. I think they did a great job. I think all the witnesses did a great job, so I'm really excited to see what happens.
Okay, and what grade are you in?
I'm in 12th grade. I'm a senior.
Okay, and have you been doing mock trial as well since a freshman?
I started sophomore year, and then I've been doing it for 3 years.
Why did you decide to participate in mock trial?
Honestly, some of my teammates who are on this team this year just came up to me and were like, you should definitely join mock trial. It's an amazing club. We love it. And so I was like, okay, I guess I'll join. And so they just kind of dragged me into it.
But are you glad they drug you into it?
I'm so glad. This has been one of the best experiences of my high school career. I would not trade it for anything.
All right. So how is this going to help you once you graduate? What are you going to go to college to do?
I'm not sure what I want to go to college for, but right now I think it really helps with my public speaking. I think it helps with team camaraderie, being able to kind of be critical of certain things, and a lot of introspection on what you're doing right and what you're doing wrong, and being able to change that. So I think it really helps with a lot of skills.
Mm-hmm. Okay, well, good luck on the future endeavors. Thanks so much for talking with us. Let's talk to another team member from Sylvania, Southview. Come on up, and if you would give us your name, please.
My name's Catherine Dong.
Right. And what was the role that you played today for the defense, Jesse Springfield?
Yes, I played the teacher, Alex Chen.
All right. So what did you have to do to prepare to be teacher Alex Chen?
Well, there's a lot of practicing being professional and seeming like, especially like a military background, because that's what Alex Chen is. And so I think we prepped a lot in that area.
Were there any questions from the other side that kind of surprised you, like you'd not been asked that type of question before?
Actually, I think most of the questions had been asked before, so I was just kind of seeing if I could be quick on my feet.
Okay. And did you have to prepare, was there a script that you prepared in the team? How does that work?
We prepare the directs, but crosses, since we can't gauge like what will be asked, we don't have scripts for that.
All right. What would you tell someone who has never participated in mock trial before about the experience?
I think it's a really great experience because you get to meet a lot of different people, and it also helps you in public speaking skills and being able to present, your material, not only be able to substantially present it, but like also performance-wise.
Right, and who knew? You were going to be live television, and you did a great job. Thank you so much. I appreciate your time. Let's talk with another Orange High School team member, and if you would, please, your name and what grade you are in.
My name is Christoph Tomsik, and I'm a senior right now.
All right, and what role did you play in today's trial?
I played the police officer, Casey Mancuso, for the plaintiff.
Okay, and what did the officer have to say about this? You basically were testifying for the school district, correct?
Yes, that officer actually had a lot to say. As previous people have mentioned, the witness statements were increased, and I mean, after playing a police officer for 3 years, in the past 3 years of mock trial, this year was definitely a lot different because a lot more went into the legal argument rather than just who said this, who said that.
So you're being typecast as a police officer. Does that mean that you're going to be going into law enforcement, or is there a legal career in your future?
I haven't really decided on a legal career. I've been interested in becoming a pediatrician since I was in 6th grade, so I'd rather pursue that. But I'm kind of keeping my views open and my eyes open on any sort of
So were you on the team last year that came to the state finals?
No, I didn't come to the state finals, but I did go to states. We had 3 teams go to states from Orange last year, and so I was on Team Madrid. So
okay, all right. Well, good luck. Thanks so much for your time today. I appreciate that.
Thank you very much.
Let's talk to our next participant, if you would, please. School, name, and grade.
My name is Chloe Antrobus, and I am from Orange. I'm a senior.
And what role were you in today?
I was the stickler principal, Jamie Gomez.
Yeah. Okay. You actually seemed rather pleasant.
Thank you.
Don't you? How do you think the performance went today?
I did my best. I thought that the whole team did really well, and we prepared and we did what we could. We did our best.
Was there anything in particular that really stood out for you in this whole process that you're like, wow, I did not know that?
Well, the crosses are definitely always a surprise because you never know what they're going to ask. And the other team had some awesome questions that I actually have never heard before. Some of the questions were new and were difficult.
And are you, did you say you were a senior?
Uh-huh.
Okay. So what's next for you after you graduate?
I am going to Loyola University in Chicago, and I plan on going into international studies and actually studio art.
All right. And how has your participation in the mock trial helped you get ready for that next step?
It actually has a lot to do with it because I've actually been doing mock trial since I was a freshman, and my speaking has increased like tenfold, my ability to just say what I want to say, and my interest in international relations definitely is connected to that.
All right. So this is prediction time. What do you think?
I don't
Orange or Sylvania Southview?
I'm not sure if I could say. I seriously have no idea. It was so close, and both sides were so prepared, and they went into it. They gave it their all, and I commend both teams.
Your international studies and being politically neutral, fabulous.
Thank you.
Good luck.
Thank you.
All right. Well, let's talk with another member of the Sylvania Southview High School team, and you were in, I think I saw you at the timers table, did I not?
Yes, I was the backup timekeeper.
Excellent.
But I'm also an attorney on the plaintiff side, so I didn't perform this round.
Okay. Well, let's give everyone your name and what grade you're in.
My name is Charlene Goyle, and I'm a junior.
What kind of time commitment was it to take care of everything that you needed to do to get ready, whether you were the backup timekeeper or you were on the defense?
Of course, being a plaintiff attorney, there's a lot of time that goes into it. I spend hours every week at my coach's house, almost every day, probably close to 10 hours a week. And the coach puts in a lot of time with everyone on the team, and he has 4 teams, so it really means a lot. Yeah.
4 teams with how many kids do you have on your team?
We have 6. Some of them have 5, some have 7, but it's anywhere between 5 to 7 usually.
And so how did your team get ready for today's competition?
Well, it was just a lot of practice and rehearsal. We had scrimmages almost the entire week coming up. We practiced a lot with our coaches, went through our directs with our roles, crosses with the other witnesses. It was just a lot of preparation and practice.
You know, you said that a little bit mentioned about your advisor, your teacher. You want to give a shout out with name?
Of course, Dennis Lyle, and Vicky Lyle, his wife, and Tony Turley.
Okay, so you had a lot of backup to help you get ready for today.
Of course, it was really helpful.
Yeah. Okay. Well, great. Congratulations. Good luck. We'll be hearing soon from the judges as they come back to the courtroom. You look very official in your uniform.
Yes,
and a police uniform. So if you would, please give me your name and what school you go to.
My name is Ridwan Siddiq. I am a junior at Sylvania Southview High School.
Okay. And you did not get to directly participate in today?
No, ma'am. I just wore this just in case we went plaintiff.
Okay. So with the coin toss being on the defense, then you weren't able to. So, but you had a good seat in the gallery, kind of watching how things went. What do you think? Anything surprise you?
Not really. I thought it was very close. I thought both sides presented a very compelling arguments. I thought it was a nice, very close up until the end, actually.
Okay. And what kind of experience is participating in the mock trial? Because you guys started like many months ago, getting ready, doing the research. As you know, as I think some other team members have mentioned, you've done a lot of practicing. I mean, could you put like a time frame on that as to like how many hours after? Was it a lot after school?
Yeah, it was a lot of after school. We'd have to give up a lot of time on the weekends, especially just because our coaches are so busy within the week. I mean, really, at first, you kind of think that it's a more relaxed process, but up until the end, you know, it gets a little tense, and so, you know, you're just trying to rush until the end to make sure you know everything accurately.
All right. Well, thank you so much for your time today. I appreciate it, and good luck. Come on up. We'll talk to some more students because there are so many students here today. It's wonderful. And you had some people in the audience who were supporting you as well. If you would give me your name, your grade, and the school that you are in.
My name's Eve Gleason. I'm a senior, and I go to Orange High School.
All right. And were you on the plaintiff today, or were you were ready for the defense?
Yeah, I'm actually playing Pat Jacobs, a witness on the defense, and today I was the bailiff for the plaintiff.
Okay, so you were helping with the time?
Yes.
Keeping time, okay. And it looked like everyone was very polished. They were all set to go. I didn't see you have to, hit the buzzer or anything or the big hook to get people off. Everything went well?
Yeah, I mean, I'm the timekeeper for the plaintiff, so in every trial I do timekeep for them, and just like through districts and through regionals, and even like at the first round or the second round of the states, it's so interesting to see how different the teams get. So like by this point, everyone is just on top of it. Everyone is so polished, and I can clearly see why both these teams are here.
Yeah. All right. Well, good luck to your team and to the others as well. Thank you so much. I think that you are actually the advisor for the Orange High School. Yes. All right. So tell me a little bit about how you think the kids performed today.
We're very proud. I thought they did an outstanding job today. They've been working at this since September. So this is kind of the culmination of all of the hard work they've been putting in, when we work after school, late at night, for the last months.
And forgive me, I meant to ask you if you want to, fess up to your name, please.
Oh, I'm sorry.
That's all right.
I'm Dave Chortis.
Okay.
And I'm the advisor for Orange.
All right. And did I understand correctly that you had multiple teams at the state finals this week?
Actually, we only brought down one, but we had 10 teams total that we had at the districts that we entered in. So we had close to 90 kids involved with mock trial this year, which was amazing.
How do you get that many students ready for something like this?
It's a challenging task, but we have a lot of great volunteers, legal advisors that come and help and dedicate their time to helping these kids learn the case, learn the law, and really help them to the best of their ability.
Why do you participate year after year to do this?
I think one of the key things for this is that you see how excited these kids get about the law, and then you get to see a lot of these kids then go to college and be part of mock trial for college, which we have kids participating in now. And finally, some of the kids that now are practicing attorneys that come back to help our team. So it really shows you how practical an experience this is outside of the classroom.
And how many years have you been participating personally?
This is about 14, I think, that we've been doing this. So it's the second year we've been down here at the state championship, and it's just an amazing experience.
Yeah. All right. Well, good luck to your team. Thank you so much for coming over here today. And
hello. Hi,
good morning. Thank you so much. Your name, sir?
My name is Denny Lyle. I'm the legal advisor and actually the founder of the Southview Mock Trial Program.
How did your students do today?
I'm always one that's really critical of the students, so they did well. We always strive for perfection. So I don't think we quite got there, but it was a good, strong competition. It was a strong finals. I think both teams were really up to it, and from that end, I'm pleased with what they did.
They seem so polished, so poised, so ready to go. What kind of pointers did you give them before they went up there?
Well, with this group, they've actually been competing since July. We were fortunate enough to go to the international championships in October with this group and won it, actually. And so the pointers have been an ongoing process there, and we bring in outside attorneys. This past weekend we brought in a panel where there was a judge, 4 attorneys that were monitoring it. We brought in a superintendent, so we'd have all the different perspectives. So we have a lot, the pointers that they get from a lot of people.
I bet. Well, especially if you're taking them to other competitions, I mean, I'm sure that helps get them ready and get them a little bit more comfortable with what they have to do. So you were talking about, it was the Empire Invitational?
That is correct, yes.
Explain a little bit about what that is.
Basically, about 9 years ago, a young man by the name of Justin Matarese decided that he would have a world championship, and it literally is a world championship. They invite the top teams from all the states, as well as schools from Ireland, Canada, Australia, Korea, and the like. They go through a selection process. The elite teams advance to it, and then we go through 4 rounds in there, and then there's a 5th round for the championship.
So an international field of competition.
It is very strong. In fact, we make it a point. The very first year we were there, we had a chance to select our opponent. We made sure it was Ireland. We wanted someone different. This year we made sure we practiced against Ireland. We went against Canada. That's part of the experience, was to be able to have that whole world experience. And, of course, that's what New York City also brings to you, too.
Right. So, obviously, the Empire Invitational in New York City, with that international field that you had, what did you take away from that competition other than the big trophy, I guess?
Well, I think we learned probably 2 things. Chemistry. These individuals here, I actually, this year's team that won it, I had less than 1 year a person when we won the Empire. So we had 10 kids with 9 years of experience. That's very little. So, but where we won it off of was chemistry. The second one was preparation. We put a tremendous amount of time in that one. And just as in this problem, each case is different. The Empire was about vehicular manslaughter. We had to learn all about alcohol and driving. And in this one, we had to learn more about the criminal field, more about the educational end. So we always try to do as much preparation as we can.
So you mentioned chemistry. How do you think the chemistry was for the team that came to the finals today from Southview?
It was good. There's always a little bit of internal conflict, which I think is good. They're pushing each other. They're all competitors. They may or may not have mentioned they were all in debates there. So most of them, this is now like the 5th or 6th week in a row that they've been in a competition format. So they're all kind of competitive against each other. And of course, a lot of the teams they saw here, a lot of the people they saw here were actually some of their fellow debaters that they saw.
Mm-hmm. And as legal advisor, why do you participate in the mock trial trial competition?
That's an emotional answer there. Sorry. My daughter, who's down there, she wasn't the best athlete, so we kind of wanted to do it with I wanted to be able to spend time with her. So years ago, I started the program. That was 19 years ago, and with the goal of trying to make sure we'd win a title with her. We won 2. So she's actually our last champion, though. That was 2004. So that was a very difficult time. And then, of course, my son had been in the program too there. So, but with Janelle, that's how it started. I was very dedicated. But even before that, I had 9 years of college training too there. So. Sorry about that.
No, not a problem. And that is so wonderful that you have taken the time to work with these students year after year. And I know they made you proud up there today.
No, it's been a family affair. This year more than ever. My wife, she had a paralegal background. She's actually taken over our openers, worked with them closely, and she's been instrumental doing that. She feeds them when they come to our house. We do most of our practices are at our house, so that's there.
All right. Well, good luck today
so
for the
much.
competition.
Thank you.
Thank you. All right. So we're still waiting for the judges to come back into the main courtroom because we'd like for them to decide today if it's going to be Orange High School or if it is going to be Sylvania Southview in our mock trial case. So we asked Lisa Eshelman to come on back, and is this unusual for the deliberations to go this long?
Well, I think what it does show us is we knew that this was going to be a close trial, and so the fact that we're still waiting for our judges to reach their decision and come back out is telling us that this is going to be a razor close finish for these two schools. And I think we all know that because of what we saw in the courtroom today. So I think we're probably minutes away, but I'm only guessing at this point. So I'm sitting here waiting and debating and excitement just with everybody else.
Yeah, I think in the kids, you can hear them in the background. They're all buzzing and excited and getting ready. We've got some big trophies to give. What other kinds of recognition do you give the students that participate today?
The teams, both the attorneys and the witnesses and the bailiffs and the timekeepers today, both the runner-up and the championship, they each will get a gavel that is engraved from OCLRE and thanking them for their participation. And then the large trophies go both to the state runner-up as well as the state championship. Last night we presented plaques. The state of Ohio plaques went to the two other schools who were in the Final Four but were not successful to come today. So they also receive it as well. And then we also know that when the students go back to their home schools, there are assemblies and recognition from their fellow students and the teachers and the principals. So the celebrations will go on for days to come.
Yeah, they mentioned that they were headed, the team that's going to go back to Cleveland had mentioned that they're going to stop at Grandpa's Cheese Barn, so we're just going to give them a quick plug and let them know that the kids are coming. And so I gave them some pointers because I go there quite often. It's a yummy place.
Absolutely. And it's always interesting because in the morning before the trial begins, it's usually pretty quiet that you can tell, and then once it's over, the adrenaline leaps, and then they're just having a great time. And that's really what it's all about.
You definitely could have heard that proverbial pin drop earlier before everything started at 9 o'clock this morning. And so now, like I said, they're all talking and laughing and having a great time. And bringing those kids together to work on this kind of project, I mean, that's part, I would imagine, of what you're hopeful, that they all kind of gel and come together.
They do. It truly is. It's a team experience. Each of them are bringing different strengths to the table. You have that analytical piece, and so when they first get the case file, they're looking at it, and then they're developing theories of the case together. What arguments work, what arguments don't work, and then they begin the actual public speaking pieces of it. So they're practicing with each other, just being able to stand up and talk in front of an adult is a new skill that the students are learning. And obviously the more they practice, the better they get. So then they scrimmage against each other. And then from that, they scrimmage with local lawyers within their communities, and all of that's in preparation for the district competition. And in the district competitions, they'll compete at least 2 times. They have to win both of those trials to move on and advance to the regionals, and that's 2 weeks later. then they go to the regional competition, and the students have to win both of those trials again before they make their way here to Columbus for the state. And so since Thursday, these students have done this trial 5 times, which is in and of itself a pretty remarkable accomplishment.
So for today's winning team, they will go to the national championship, which is coming up in a couple of months in Wisconsin. Is it the same case? How does that work for the national competition?
It's a clean slate. And so there'll be a brand new case that is released first part of April. And so all of the students across the country start off with a brand new case, new witnesses, new attorneys. And so then they have a very, very short time period in which to learn a brand new fact pattern and new law and prepare their arguments before they head up to Minneapolis.
Okay. Well, we certainly will look forward to that. That's coming up here. Thanks so much, Lisa Eshelman, who is the Executive Director for the Ohio Center for Law-Related Education.
Well, thank you. Thank you for such a wonderful day today. Okay.
It's been a lot of fun. Well, I think the judges are going to be coming back, so let's go to the main courtroom and find out what they have to say.
I'm going to reserve my comments for last and let the scoring judges make their comments first. The only thing I'll say to start with is obviously you both did a fantastic job. Every year when I do this, I think it can't get any better than what I've seen before, and I leave feeling, wow, this was, if not the best, it has to be right up there. So you both teams did a fantastic job. We'll start down at this end, if that's okay.
Great competition. It was very difficult for us to decide. You were all very, very well prepared. You've obviously read the materials, knew your materials, but you also grasped the law, and that is very impressive to all of us sitting up here. Not only the rules of evidence, but also the case law. You clearly came prepared. We were very impressed with the level that you showed here today. We're probably thinking that some of you are going to be attorneys someday, and kind of hope so, because we'd like to see this come into the bar. I can't really find anybody at fault for anything. I mean, it was excellent. As I said, it was just very, very difficult to score. And as we convey that to you later, you'll see that. So thank you for doing this and participating in this program. It's wonderful for you, but it's also wonderful for us to see that we have a good base coming up through the ranks and hopefully replacing us as we retire. Thank you.
I hope I don't retire too soon, Judge. First off, congratulations. This was an absolutely wonderful experience for you, and it was an absolutely incredible experience for me. I'm a former legal advisor for 5 years, dating back a few years. I won't tell you how long it's been since I've served. But what I'm most impressed about and I'm most happiest about is that as the president of the State Bar Association, I go around the state talking to lawyers and community leaders all the time about educating our children, about civics education, preparing you to inherit the government and take over and be leaders in the future. And when we come to a program like this and we see such stellar folks such as yourself demonstrating your acumen and your knowledge about the government and your understanding as to how it all works, even though you haven't spent one day in law school, you impress me greatly. I'm just so proud to have been asked to serve. I appreciate all that you've done, and I'm sort of excited. I want to get on to the announcement as to the results, Your Honor.
I'll tell you, as an Ohio State Bar Foundation president and trustee, this really comes home to me. The Ohio Center for Law-Related Education's programs are terrific, and I love that because we are financial supporters of OCLRE, work very closely with them, and to see this end result of the mock trial program this year is just wonderful. We are supposed to give observations about the strengths and weaknesses of the teams. I can't really do that. I see no weaknesses in any of the teams. I think either of you, your strengths were just wonderful, and it even extended beyond, I think, mastery of the materials. You were civil to each other. Your demeanor was dignified. You were all persuasive. Excellent work product, terrific preparation, great delivery, and we have this very detailed scoring tabulation sheet, and I will say that I could find no way to put anything other than excellence on every single category for every single person. I thought you all were terrific. What a privilege for us to be here in this capacity. What a great day to do this. It's just wonderful. Thank you.
Yeah, there are no weaknesses at all on either team. I mean, you're just great, right? All four attorneys, all four witnesses. And some of the things, I mean, I've a coordinator at the district level and the regional level, and of course, helped judge in a couple trials in the state competition before this one. And things that were immediately noticeable to me, there weren't as many objections as in some trials, but that's because the attorneys were just so sharp in terms of the questions, the witnesses were so sharp in terms of their answers. And when you did make objections, both sides just did a wonderful job of arguing your objections. And the witnesses, were so believable in each of your roles, and there weren't very many, when you look at objections, invention of facts objections, you didn't have I don't think any of those in this trial, and that's just because the witnesses were so good in terms of answering the questions and responding to the questions, and again, the attorneys were really good with their questions. So, exemplary, great job. Parents, you obviously, and family members, you have good reason to be extremely proud of your children. And I know you're really appreciative because your parents have been, and family members have been supporting you in all of this for all the support they've given you. And I can't help but mention, because I know how much work they put in, the teacher and legal advisor for each team did a fantastic job. And if you would all join me, and if you would stand up so we can recognize you. Because your good work was very apparent in this trial also. So at this point, Todd.
Thank you, Judge McBride. Before we proceed to announce the award winners, first I want to echo the judges' comments in congratulating both teams. Of the more than 330 teams that participated in the competition this year, I think it's absolutely clear that we saw the best two compete today. I also want to thank, as the judges did, all the teachers, lawyers, parents, and other supporters that helped you get here. We know they were a part of this process also, and a very critical one. I want to thank our judging panel for their support and all the other judges that helped us throughout this competition. On behalf of the Ohio Center for Law-Related Education, I would also like to thank our sponsors, the Ohio Attorney General's Office, the Supreme Court of Ohio, the ACLU of Ohio, the Ohio State Bar Association, and I'd also like to thank the Ohio State Bar Foundation for their support throughout this process. At this point, I'd like to invite Judge McBride to step down from the bench, and we'll proceed to recognize each student on the team. I'll ask an advisor from each team to come up, introduce his students. Each student who participated will receive a gavel from Judge McBride. At the conclusion of that, we will announce the individual award winners, both for Outstanding Witness and the James E. Phillips Outstanding Attorney Award. And after that, we will announce the 2014 Mock Trial State Champion. At this point, from the plaintiff Orange High School, I'd like to invite Dave Cordes up to introduce his team. Should we go ahead?
Dave Cordes. I just wanted to, first of all, I wanted to thank our advisors, too, to kind of piggyback on the comments that were here. One of the things that our chief legal advisor couldn't make it because he's working in Denver. So that's one of the things, Chuck Jarrett, who's been vital to the program. Also, Vikas Tarakia, who works with me, who's here as an assistant advisor, Pippa Carter, and Alicia Turner, who's not here. So we've had a lot of great volunteers. And just to kind of add to that, if we could give a round of applause for all of the volunteers that have helped with this program right now, I'd appreciate that. All right, just to announce our team, attorneys, first of all, those that participated here. First of all, Ariana Sequeira. Secondly, Megan Shanklin. witnesses today, Chloe Antrobus. Another witness today, Christoph Tomsik. Our amazing bailiff, who also played a witness on the opposite side, Eve Gleason. And two more members who are attorneys on the other side. First of all, Amy Wu. And finally, our club president, who was also in the state finals last year, Shivangi Bhatia. Seven amazing seniors. Thank you, guys.
Thank you. Congratulations. From the defense, I'd like to invite Denny Lyle to introduce his team.
Thank you. I think I speak for Orange and myself, but we greatly appreciate the efforts that the auxiliary does, Lisa Eshelman and Todd. It's been instrumental in providing us with a wonderful educational opportunity there. I'd also like to congratulate the Orange team. They were phenomenal in this round, and it was obviously a very exciting moment for all of us, and we'll see that in a moment. I'd also like to thank my coaches who are not here today, three of which haven't been able to travel with us. One was Dan Ellis, one was Tony Turley, and one was Fritz Byers. However, perhaps the most important one is my wife. And her name is Vicky. I'll be introducing my performers today. My senior and lead attorney is Chen. His co-counsel was junior Eric Zhu. Performing as Jesse Springfield was our sophomore, Zach Pizjekai. Senior, and playing the role of Alex Chen was Catherine Dong. Our other two performers for this team were Shalene Goyle, a junior, attorney on the opposite side. Final member of this team is Ridwan Siddiqui, who no doubt was the officer Mancuso, given his uniform. And I would like to thank the members of our team that did qualify for state, the Orange team, coincidentally, who also are here today in support. Thank you so much.
Thank you. At this point, we will recognize the individual award winners. An award will be presented to the highest scoring witness and the highest scoring attorney from today's trial. Our outstanding witness from Orange High School is Chloe Antrobus. The Crystal Award. Oh, sorry. The Glass Award. Our James E. Phillips Outstanding Attorney. This award is named for the founder of Ohio's high school mock trial with a perfect score of straight tens on every ballot from Sylvania Southview High School is Chen. It's now time to announce the 2014 Ohio High School Mock Trial State Championship winner. The 31st state champion of Ohio High School Mock Trial is Sylvania Southview High School. At this point, congratulations, Sylvania. And please join me in congratulating on a great season, Orange High School. Go up and get your award. This concludes the 2014 Mock Trial State Championship. Thank you all. Congratulations once again.
You've been watching the Ohio Channel's coverage of the Ohio High School Mock Trial Championship competition. Congratulations to the winning team, Sylvania Southview High School. They will head to the national championship in Madison, Wisconsin. To purchase copies of this program or to view it for free online, visit us on the web at ohiochannel.org, where you can also view live and past video coverage of your Ohio government. Thank you for watching, and we see you next year.